So I could not go through it. So can it be after vacation? My Lord, maybe. Yeah. Well, I don't have the calendar after vacation. Obliged.
Other side?
Other side, I have informed them.
Okay.
Mr. Ghosh was there. I had a talk with him.
Senior counsel, Mr. S. Doctor, no?
My.
With the consent of the other side, has prayed for adjournment. List the matter on 8 January.
Obliged.
May I please, Lord?
Mm.
I'd like to mention for listing one CRP matter for admission in the last part of January, Lord. So last week of January, maybe 28th of January.
Prayer for listing of a first appeal against order, my lord. Our injunction was rejected before vacation, my lord, any day for motion. FAO. Injunction was rejected. Injunction prayer.
19 DD.
19. Highly oppressed.
May I please, Lord, I beg to mention.
আৰু আছে নেকি civil bench 1 নে অকল এইখনে নেকি?
416.
হা 416
My Lord, I beg to mention for listing one CRP for orders, Lordship, on Thursday, Lordship.
why orders CRP for orders?
My Lord, the title is pending before the Larnet Court. And during the pending of the suit, the father of the petitioner expired. They filed a substitution petition but not allowed by the Larnet Court.
They had filed substitution petition which was not allowed.
Yes.
Okay.
Okay.
May it please your lordship, I beg to mention item number 34. Lordship senior is having some personal difficulties.
Okay.
Can the matter be fixed on the second week of January? 34 hearing.
Who is your
Old-
senior?
D. Chaudhary.
My lord, old pending case. Your
my
name?
lord.
What is your
S.
name?
Sharma.
Huh?
S. Sharma.
S. Sharma. Yes.
I am for the defendant, respondent, your lordship. My
Very
lord.
old case, yes.
Very old case, my lord, by taking advantage of staying order. Yeah.
Okay. One last adjournment.
Lordship.
Learned Counsel, Miss
S. Sharma.
S. Sharma, on behalf of Learned Counsel,
D. Chaudhary.
Mr. D. Chaudhary has prayed for adjournment.
Let
Learned
me-
Counsel, Miss
F. Begum.
F. Begum, appearing for respondent number 1 and 2, has raised serious objection, stating that this is an old pending matter and the appellants have also procured a stay order and they are protracting their case. List this matter positively for hearing on 20 January.
Please, your lordship. I beg to mention for listing up two MSc appeal, the order matter. After vacation.
May I please your lordship? Lordship, I beg to mention is listing for orders to one MSc appeal and one IS appeal. IS appeal for condemnation of delay. Lordship, it's January.
Yes. Yes.
But please, your lordship, I beg to mention for listing to RFA matters, the same subject matter, lordship, can be listed on Thursday or Friday.
Why RFA is same subject matter on Thursday? Why? What?
There's a counterclaim, lordship.
Huh?
There's a counterclaim in it. So lordship, they can be listed on Thursday, it's a motion matter, fresh matter, lordship.
Appeal, motion matter, fresh.
Motion matter, fresh matter. Maybe Thursday or
Thursday পারিনি. No. For after 14 days, January. 6 January.
lordship, it's a motion matter, lordship.
5 January. 5 January.
May I please your lordship? Lordship, I'm praying for listing of two CRP IOs which has been filed for today. Lordship, can it be listed?
Today.
Because lordship, the matter is fixed on 22nd of
What's
this.
the matter?
It has been derived out of a title suit and the petitioners are here against a order passed by the land.
What's the order? What kind of order? CRB against order,
Yes,
revision petition.
yes.
You want, what kind of order? You want it on Thursday?
Yes, lordship.
No. 5 January.
Right.
May I please your lordship? On lordship direction, yesterday lordship, I have filed an additional affidavit. Matter is today listed in supplement. That will be called for lordship.
Okay.
May I please, your lordship? I beg to mention for listing of a criminal appeal, lordship. Matter will be fixed on Thursday.
Criminal appeal on Thursday for what?
Orders.
Huh?
Order.
What kind of order? Oh, criminal appeal, yes. Not before this court. কোনটো court কৰি আছো কৈ দি নাজানিব পাৰে কিন্তু ক'ত কৈ দিম দেৰিয়ে হৈ গ'ল দিয়া go hurry up code 6
Lordship, this is an application filed under section 24 seeking transfer of titles or divorce from the Court of Additional and District Judge Golpara to Kamrup Metro Guwahati, where petitioner is currently residing in her parental homes along with her minor children also. So the fact is,
issue notice
Lordship, till pendency of this case, Lordship, the further proceedings in Golpara may be still.
till what at what stage it is pending
It was it was fixed for ex parte hearing, Lordship.
okay
And then petitioner had approached, but the order is not yet uploaded in the website, Lordship. That is the issue. Because, Lordship, the very purpose of this petition will be defeated, Lordship, if the further proceedings are not stayed, Lordship.
it was fixed for expert hearing where is the last order
Last order, Lordship, I have to check it out, Lordship.
you have to fix the order when you are submitting something without substantiating documents how can I pass an order you are saying that it is fixed for hearing then there has to be an order without an order a case won't be fixed for hearing where's the last order so which page
I think I have not annexed here, Lordship.
then how will I believe you if you have not annexed then how can I rely on your submission oral submission
Lordship, but I have annexed, Lordship, the copy of divorce petition filed and the written
no
statement
it
that has
is
been
not
filed, Lordship.
you are saying that you are in urgent need or divorce petition's copy will not substantiate that you are in urgent need
Lordship, it is urgent because she is having.
no see you submit from the record no you submit from the record if it's urgent show me from the record we are showing me from the record how can I pass an order stay you know there are so many judgments not to grant stay so when you want a stay then you show me on record in black and white oral submission will not work best I can do is issue notice
But keeping in consideration, Lordship, she is having.
how can I keep in consideration where is your petition where is your not petition where is the order last order that it is fixed for what you have said ex parte order where is the last order
There has to be annexed, but yes,
you
Lordship,
bring it annex it tomorrow then
by filing IL.
it's up to you it's up to you if you are insisting on stay then you have to have supporting documents
Yes, Lordship.
okay day after tomorrow
Tomorrow, Lordship, tomorrow.
okay list this matter on PDF type code pe deliver sonkal
I'm out, Lordship.
you hurry up don't be late
Yes.
because this is fixed for tomorrow then you'll have to be ready with all your copies
Yes, Lordship.
May it please the Lordship, my lord, I'm sorry to mention one thing, my lord. I was wrong impression. I went to court number 16 for a mentioning. The court said that senior bench is here, you have to mention there.
okay
But, my lord, only thing I have to mention one thing, my lord. I have filed a suit for specific performance. Notice was issued on injunction. Other side has filed objection. Now, my lord, the dates have been provided after 4 months, 5 months. Order 39 does not provide that, my lord. For preponing the matter, I am challenging that order, deferring the matter after 4 months, 5 months, a 227 application. I filed it earlier. Can it come on Thursday as a motion, madam? All day is a motion.
Thursday we have too many cases last one down পাই নেকি বহি যাব নাই নহব এইটো ইনজাংশন মেটাৰ হয় ন
Thursday, madam, Thursday.
okay
Yes.
An order dated 5/7/25, my lord, passed in civil judge senior division 1, my lord, title execution number 29 of 24, my lord. Holding that, my lord, property executed by surveyor on demarcation, my lord, without any, my lord, boundary pillars, my lord. How can you say 18, my lord, order? Without determining this boundary of this land, my lord.
Okay, we'll issue notice. You are coming against this order.
My lord.
We'll issue notice. It's already executed, so where is the urgency? Okay. Lion Council, Ms. R. Begum.
L Wajida, my lord. L Wajida.
L. Wajida is present for the petitioner. Issue notice to the respondents returnable on date of January.
Oblige, your lordship.
Item 3.
Lordship, this case has been filed against the order dated 35/2025. This is passed by the MSC Court number 3, Kamrup Metro. Lordship, in case number MSC case number 659/2023, Lordship. Lordship, the
Judgment,
fact, Lordship.
judgment.
Yes, Lordship.
Okay.
The
But you have preferred a revision petition.
revision petition, Lordship.
Why not an appeal?
Lordship, actually, I'm going to that point, Lordship.
Okay.
Lordship, actually, the fact was an accident occurred on dated, Lordship, 14/10/2022, Lordship, with my car, Lordship. And my car has been damaged from the front side, Lordship. And thereafter, I called police. Dispur police came there and entered GD. Thereafter, next day, I lost an FIR, and accordingly, FIR was registered, Lordship. Thereafter, the police could not communicate with the accused person, Lordship, actually. That is the thing. And I did not get details about the accused person. And the limitation period was only 180 days for this case. And finally, I have filed this case on 178 days, Lordship. But the police did not provide me all the documents, only provide me a police report where the case number is clearly mentioned and the simple fact is there, Lordship. And I have filed this case along with that documents, and accordingly, next date we serve the notice as per the order of the court, and then receive the notice. But court given them so many times opportunities, but they are not appeared to file WS, Lordship. So thereafter, the case has been passed our ex parte order, and thereafter we submitted evidence, and in the evidence I have submitted the documents which the police Lordship issued me, Lordship. And in the meantime, Lordship, the honorable member of this tribunal has been transferred, Lordship, and a new member has allotted there. And in the argument period, Lordship, I have argued, but in the judgment, it is dismissed in the opinion that I have not submitted any certified copy of the FIR, Lordship, or FIR or charge sheet, Lordship. Therefore, it is not proved that there is a accident case has been registered in the Dispur police station. But your Lordship, I have submitted the police report, MBI report. My car has been seized, and thereafter it was MBI report, and one is FIR copy on photocopy on the of the FIR given me. And all the three documents, it is cleared the case number, Dispur PS case number so and so under section. So I have come here because, Lordship, thereafter I applied for certified copy of this case. I received the certified copy now, FIR and charge sheet. So it is seen that the police investigated the case more than 1 year, Lordship. The accident occurred on dated 14/10/2024, and the police submitted charge sheet, Lordship. It was on 10/12/2023, more than 1 year. And now I have received the certified copy of FIR and charge sheet, Lordship. So that's why my prayer is, Lordship, Honorable Court may set aside the order with the direction to the trial court to review the petition again. I'll submit the certified copy of the FIR.
Read the judgment.
Yes, judgment in pages, Lordship. 19.
Hmm.
It was my own car, Lordship.
Hmm?
My own car.
Okay. Your own car.
And I was the
Read the
driver
judgment.
there. 19, Lordship.
Hmm.
And the Lordship, one important thing is that the Honorable Court never call any CW if there is any confusion.
No, the order may be correct. You read the judgment.
Lordship,
Read the judgment.
maybe. It is a very long judgment, Lordship.
You'll have to read it.
Lordship?
You'll have to read it.
Yes.
Otherwise, how will I pass an order?
Okay, Lordship. Let me,
Or else you sit down, I'll read it.
okay. Let me read the point number 26, Lordship. This is very relevant.
How will I understand the case from point number 26? How will I understand the case?
Okay, Lord.
You sit down, I'll read it.
Lordship. Okay.
What is your
If
prayer now? At present, what is your prayer now?
prayer, I have collected the FIR copy and charge sheet.
You want me to pass an order today itself?
Yes, Your Lordship, with the direction to
Okay.
consider this.
So I'll have to read it.
Okay, Lordship.
Hmm.
Lordship.
I'll read it. You sit down, I'll read it.
Okay, Lordship.
Sit down. It takes some time, at least 10 minutes.
Okay,
It's a
Lordship.
long judgment. Police vehicle.
Lordship.
That vehicle was a police vehicle.
Yes, Lordship. The offending vehicle was a police bus.
Okay. Police bus.
Police bus, Lordship.
So you have given all photocopies.
Yes, Lordship. Photocopies and the police report that was original. The police report was original.
So why didn't you ask for a review in the court?
Lordship, because I have sufficient documents now, whatever the court want, it is written in the judgments. The court need,
Why didn't you ask for a review in the court?
Lordship, it is dismissed without any award. It is dismissed without any award. I have already explained 19,000 something. I have given the original voucher in my evidence.
Now you have the copies, have you annexed the copy
Yes.
of the FIR and the
No,
charge sheet
no.
along with this petition?
This is the original.
Okay.
Not the original handwriting.
But you haven't sustained any injuries.
No, Lordship.
So, I think a consumer forum would have been the better forum
No, it is,
for damages,
it can claim under section 166 of MBA.
166.
Yes, Lordship.
Damages.
Lordship for damages.
Yeah,
And,
damages of vehicle or building.
No,
Let's
any
go to
property,
166 of the
any property
Yes,
cost,
property, I
any
think that's what
property
I'm saying,
more than 50 rupees. Value more than 50 rupees.
2019, no?
And it explained in, under section 427 of IPC also.
No, you will not go to IPC. You see, she has correctly held. One 158(6) of the MB Amendment Act.
Yes, sir.
Information regarding any accident involving death or bodily injury to any person.
Lordship.
Then she has held that according to the mandate of section 166(4) of the MBA, the claim tribunal shall treat any report of the accidents forwarded to it under section 6
Lordship.
of 158.
Lordship.
So it has to be read conjointly.
Actually, it is the duty of the police. I think police has done all the procedure. And in general, accident case, Lordship, we have filed.
Given compensation for truck destroying
Yes, Lordship.
shop houses. I have.
Yes,
given
Lordship.
compensation.
Lordship.
Let's see what.
And so many
Just a moment. Let's see 158. Okay. All right. all right. Which page? FIR charge sheets? Your charge sheet and FIR?
Yes, Lordship. FIR on 28, Lordship. And charge sheet 36. Lordship, in the FIR form, you can see there is not mentioned the accused person name, the driver of the bus only. It is written. In page number 33, Lordship. Point number 7 at bottom of the space. Page number 33, point number,
Where's the original FIR?
original here, Lordship.
Oh, I got it.
Yes, Lordship.
Page 33, no?
Yes, Lordship.
Page 33, okay. And charge sheet?
36.
Your petition is under which section? CRP?
160,
No, no, CRP.
115. 115 and read with section Article 227.
So in this entire MV Act, there is no provision for revision. There is provision only for appeal.
Yes, Lordship. But they suggested me, the concerned bench suggested me that you can go for revision in the High Court.
I do not know. You'll have to satisfy me on that score.
That's
They-
why, Lordship, I prayed for reviews. Pass an order for review the earlier judgment.
This is for review.
Yes, Lordship. Lordship, pass an order.
115 of the CPC.
No, Lordship.
Hmm?
I prayed, Lordship, for to pass an order to review the judgment, Lordship, by that concerned court.
And Article 227 of the Constitution.
Yes, Lordship.
That's all. But 115 is revision.
Yes, Lordship. Revision.
You'll have to satisfy me on that score.
No, Lordship. My submission was like that. The Honorable Court may pass an order to review the judgment, Lordship.
That's
This
what
court,
I'm saying. You're not getting my point. This entire MB Act, there's no provision for revision or review. There's only provision for appeal.
appeal, Lordship.
And that too finally they disposed of case. You'll have to satisfy me on that score. I'm not satisfied. At best, I can issue notice. Only notice.
Okay, Lordship.
I'll issue notice only. And if you want anything else, any more relief, then you'll have to satisfy me. On that point, what I have
Satisfy Lordship, that means I
See,
have,
I am not satisfied.
yes, I have already
You'll have to
submitted the
give
doc.
me, you'll have to give me confirmed answers,
Confirm.
confirmed answers with authorities. Uncertain answers will not do. With authorities, you'll have to give me. At best, I can issue notice. I have really worked hard.
Yes,
I have read the judgment, I have read the provisions.
yes, Lordship.
I'm not satisfied. So best I can issue notice.
Lordship,
Or if you want to assure me, then you'll have to give me some valid grounds.
valid grounds for regarding accident
See,
or
this is a disposed of case.
Lordship?
This is a disposed of case. What
Yes.
I'm saying that I don't want to repeat again and again. If you could follow my what I'm
Lordship-
asking for,
Lordship,
I can fix a date.
the honorable court actually could not consider, fail to consider my evidence, Lordship.
So you have to come in appeal.
Okay, Lordship, if you, Lordship, pass order to
No.
serve notice, Lordship,
Yeah, I'll pass out, I'll
then
issue notice.
final order will be passed by this court.
Yes. Order will be passed by this court. I'll issue notice.
Award may be passed.
No, I'm asking you certain questions. You are not giving me proper answers. I'm asking you X, you are answering me Y. You're not giving me answers for X. You're giving me answers for Y. So if you can assure me that you can file a revision
Yes,
and then a petition, and on the revision petition, I can pass an order for review.
actually,
I'm not certain that I can do that.
I have filed revision. To review, to pass an order to review the judgment.
That's what I'm saying. You have filed a petition for review, but you are petition for revision, you are asking for review, but there is a provision for appeal only. That's what I'm asking.
Okay, Lordship, honorable court may pass to file a appeal.
No. Why should I? It is your duty. How, in what manner you come, you want to come? before the
Limitation
court?
period is there, Lordship, I think.
Huh?
But limitation period is there. So with
Limitation will start from now. As soon as I dispose of this, it will start. And if I, you see, how many days you delay will occur? If I fix a date from today, to say day after
60
tomorrow,
days maybe.
huh?
60 days maybe.
Don't you think the 60 days of limitation is always condoned? This code always condones. Sometimes 1000 days also delays.
Yes, Lordship. Okay, Lordship, dismiss with the
Should I issue notice?
No, Lordship.
As soon as this case is disposed of, then you can easily start your limitation from that day.
Lordship, case may be disposed, but with liberty, Lordship.
Yes, no, why should I dismiss? Why? I must know whether you have a valid case or not.
Yes, sir.
It's your duty.
Whatever court may think fit and proper, Lordship. Whatever court may think and proper,
So I'll issue notice then.
Lordship.
Issue notice to the respondent returnable on date to return. Call for the trial court records. Item 4.
Obliged.
You can pray for withdrawal also. If you discuss with your seniors and come up with a proper answer, you can pray for withdrawal also before 19th.
Okay, Lordship. May I withdraw now?
It's up to you. You ponder over it, you ponder over it. Don't take a decision in haste. Ponder over it. I'm here till 19th,
Okay, Lordship.
but come before 19th.
Lordship.
Very please.
Hmm.
My lord, here, my lord, the revision, we are challenging the, my lord, the order pass, injunction order, my lord, pass against the, my lord, the landlady, my lord.
Hmm.
By, at the petition filed by one, my lord, respondent, my lord, who is a, my lord, prospective purchaser, my lord.
Hmm.
One agreement for sale was entered to sell one katha of land. And but the, my lord, that agreement ultimately, my lord, for some dispute raised by the opposite party, my lord, she want a different structure of land. That agreement has to be cancelled from the side of the, my lord, petitioner, lady, my lord, who is the landlord, my lord. And she has also corresponded to the, my lord, respondent that I have cancelled the agreement for such and such reasons, and I have returned the money which you have paid to me towards advance, my lord. The money has also been returned to her through checks, and it was delivered, and it was accepted by her. Later on, my lord, the opposite party, what she did, my lord, later on she, through another letter which I have annexed here, she returned back the money through check, saying that no, I have filed a suit against you seeking in the specific relief. Now, my lord, in the suit, my lord, they have prayed for some permanent mandatory imprisonment to restrain us from alienating my property to my family or to any other.
Okay.
Now, my lord, in page 100, my lord, the learned civil judge, my lord, while passing the order, my lord, committed jurisdictional error, my lord, have passed the order, my lord, restraining us on transferring the suit land and the entire land, my lord. I'm coming to the submission of entire land, my lord. Your lordship will see schedule page 106. The entire land, my lord, which I am possessing, my lord, that land, the order has been passed. Although, my lord, that my lord cannot be passed, my lord, because no schedule, my lord, was there to properly identify. Page 106, my lord.
Where is the plaint?
Plain, your lordship will please to come, my lord. Page 26, my lord. And schedule, your lordship will find page 40, my lord, 40.
This is the plaint.
Yes, lordship. Page 26 is the plain which was filed by that prospective purchaser. And and page 40 is the schedule, my lord. That is one katha of land of dark number so and so covered by so and so. Now, my lord, then one katha is under 3 katha, which I am also possessing, my lord. And my sons have also possessed the land. Now there is under order 7 rule 3, my lord, they have not amended the plain, my lord. When it is required to identify a property, my lord, it has to be clear description and identification so that they, in passing the judgment, my lord, decree can be executed. My lord, that was not done. That is the first point, my lord. And on support of that, my lord,
No. She has passed an order only relating to 1 katha land only. A land measuring 1 katha out of total land measuring 3 katha.
yes, Lord, 1 katha, my lord. That 1 katha is under 3 katha of land. But
not entire land she has not.
1 katha, my lord, there are, my lord, several, my lord, parts of land, my lord, here. 1 katha, which 1 katha north or nothing has been mentioned, my lord. And thereby, my lord, it is affecting the entire plot, my lord. 1 katha, which of the description your lordship will see, I am coming to that one judgment, lordship, just for a moment.
No. This is the plaintiff's land, and then this is the suit land, and then she has passed an order only in relation to the suit land.
Suit land, my lord, restraining.
And then
from,
the part is your plea.
No, I have stated that the land which they have wanted was triangular in shape at that time. Now they, my lord, the respondent opposite party, while taking measurement, this is pleaded case. While taking measurement, this is claim another plot of land. And now by that, my lord, they want to.
I
get the-
understood.
Yes.
Mm.
Now your lordship, another point, my lord. When the agreement was done, my lord, your lordship, agreement for sale was done, page 56. Admittedly, they are not in possession, my lord. They are not in possession. This was just a unregistered agreement, page 56, for sale of land, my lord. By virtue of this agreement, my lord, your lordship will find they have paid 8 lakhs total. 4 lakhs first, then second installment, 8 lakhs as advance consideration. Now against that, my lord, because of dispute created by them, my lord, we have stated that they want another plot of their own choice. Later on, they created that dispute that I want this plot, because that plot cannot be, because that belong to my son, my lord. Now, we then executed an agreement, page 60, from the side of the petitioner landlady, page 60. There was some mutual understanding that, all right, we'll not proceed, we'll take back the money, my lord. Page 60, my lord, this notarious affidavit has been done, where the petitioner number 1 have agreed to return all the amount and cancel the agreement for sale. Now this page 61, your lordship will see, the agreement was cancelled from the side of the petitioner with information. Now, my lord, I'm coming to relevant portion, my lord. 69. Page 69, your lordship.
Okay.
After cancellation, the agreement from my side for the impossibility created by them, we have no dispute, nothing, my lord. Each and every correspondent we replied. Page 69, my lord, we have returned back the amount to all the checks. Page 71, my lord. We have returned to the opposite party. Now what she did, my lord, your lordship? The amount which we have returned, my lord, that has been acknowledged, page 72. It's a type copy, your lordship. And page 74 is the copy letter written by the opposite party. And the envelope is also there, page 76, my lord. Page 76 is the envelope through which this letter has been sent to me, my lord.
Page,
Page 74, my lord.
acknowledgement.
Page 76 is the acknowledgement letter. Envelope.
Page 76.
Yes, ma'am. That is the letter accompanying the letter. Page 74 letter.
And where is the acknowledgement?
76 is that registered post acknowledgement. It's issued from the post office to me, my lord. To Midula Gogoi Ahmed from Nomi Keot, my lord. And it is in her own handwriting, opposite party. Page 74. It
Where
is,
is it? Let us go to the order then.
yes. Now, when I have returned the money, my lord, and I have cancelled the agreement, my lord, because of impossibility created by the opposite party, my lord.
It's okay.
Because
Let
she
us
was,
go to the order.
yes, lord. Page 100, my lord. 10, 11, 25. Your lordship will come to the finding.
No, I'll not go to the finding. I'll read the order.
Yes, order, my lord. Page
You read,
100.
I'll read.
I'll read, my lord.
Okay.
From page 100, my lord. Entire order, my lord.
Yes.
This Miss J case has arisen out of petition bearing number so and so, filed by petitioner plaintiff under order so and so, praying for granting temporary injunction restraining the opposite party from alienating the suit land by of sale, gift, mortgage, and also from constructing any illegal construction over the suit land till disposal of so and so. Today was fixed for hearing. Accordingly, I have heard the learned counsel for both the sides with reference to their rival submission on the point of granting and rejection of prayer of injunction petition. Learned counsel for the petitioner has drawn the attention of this court by reflecting that the petitioner had entered into an agreement for sale with the opposite party on 1/2/2023, wherein the opposite party was supposed to sell a plot of land measuring 1 katha out of total 3 katha 17 lisa, covered by dag number so-and-so under so-and-so Moja within Dibrugarh district for a consideration amount of rupees 9 lakh, out of which an amount of rupees 4 lakh was paid as an earnest amount at the time of entering into a notarized agreement for sale. It is further contended that the petitioner had paid another advance amount of rupees 50,000 and rupees 3,50,000 on 5/3 and 6/5 respectively to the opposite party. It is further contended that after receiving the aforesaid money from the petitioner by the opposite parties, they were supposed to take necessary steps in the revenue office for smooth conducting of the sale, in spite of which they have failed to do so by resorting to one pretext or the other. It is also contended that opposite party number 1 had sent an affidavit cum declaration, that is the petitioner number 1, to the petitioner through which the opposite party had cancelled the aforesaid notarized agreement for sale bearing so and so dated 1/2/2023 without any consent and information of petitioner. It is further contended that as per information received by the petitioner, the opposite parties at present are in verge of disposing of the suit land, measuring 1 katha in favor of some third person, which has compelled the petitioner knock the door of the court praying for so-and-so money. Per contra, learned counsel for the opposite parties has vehemently objected to the prayer made by the learned counsel for the petitioners by reflecting that the opposite party have always tried to settle the matter and to execute formal deed of sale in favor of the petitioner. But the petitioner and her near relative misbehaved then on various occasions, and it is the petitioner who had failed to perform her part in executing the formal sale deed by creating various problems when the opposite party have tried to talk with her. It is also contended the opposite party number 1 had cancelled the notarized agreement for sale executed between the petitioner and opposite party number 1 by executing an affidavit cum declaration by informing the petitioner. It is further contended that the facts narrated by the petitioner are frivolous, concocted, and devoid of any merit, and as such have got no right to claim any relief over the suit land. Learned counsel for opposite parties has also stated that opposite parties were ready to return the advance money to the petitioner, but he had refused to receive the same. We have returned money. In view of above, the learned counsel for the opposite party has pressed for dismissing the prayer of the petitioner. Upon hearing learned counsel of petitioner as well as opposite parties with reference to the merits of their submission, I am of the considered opinion that in order to grant temporary relief to the petitioner, the 3 golden principles so and so, prima facie case, measurement of balance of and factum of irreparable loss and injury is need to be considered accordingly upon perusal of facts of the case. It appears that petitioner has reflected her grievance with respect to alleged attempt of alienation of the suit land by the opposite parties in spite of receipt of a considerable quantum of earnest money for selling the suit land, and in view of which the petitioner has submitted a photocopy of Government as document number so and so, copy of agreement of for sale as document number 2, photostat copy of affidavit cum declaration as document number 4, so as to corroborate her contention. That being the proposition, there appears a pertinent question to be decided by the court with reference to the claim being raised by petitioner.
Okay. All right. It's okay.
I have returned, my lord. There is no violation from my side. And there is sufficient provision under specific for
So
damage.
this agreement
Yes,
was only from one side, Vidla Gogoi.
Vidula Gogoi.
Not Kyaut.
yes.
So you do not have a case of stay.
No, agreement was initially, my lord,
No, where
This
is
was
the mutual
done,
agreement?
persons to a malad.
The language shows that it was mutually done, but the signature is of only one person.
Yes, my lord, that was on consent we have done, my lord. But the thing is, my
But
lord,
there's no consent. You have, the other party has denied all any consent.
that is, my lord, in the suit we will prove, my lord. But the thing is that, my lord, there is no question of alienating the land to
So
anybody
I
else.
do not have any prima facie to the case to grant stay. Will issue notice. Will
But
issue
your
notice.
lordship may, for a time being, because your lordship will see section 41 also, my lord. Section 40 of specific relief also.
Mm.
My lord, it says, my lord, section 40, my lord, is 41 is when injunction when refused.
Defect.
Because they are admittedly not a, my lord, purchaser, and they are not in possession also. What we are, my lord, loss is that the owner itself, my lord, lady. And we are ready to pay the money, and we have paid also, man. That is the thing, my lord.
But they have returned the money. No?
Return the mailing, my lord, with malafide. They want to take one plot of land, another plot of land. That is the thing, which is now in possession of my son. We have stated, my lord. And there is a sale deed also, my lord, belong to my son, that land. They want to shift from that triangle portion to another square portion of land. That is not in the schedule also, my lord. That is the thing, my lord. Page 41, if your lordship will see, sorry, section 41. Section 41, my lord, an injunction cannot be granted. Subsection D also, my lord.
No, we'll issue notice.
My lord, till that time, my lord,
No, no,
because it may affect, my lord, the rights of the other parties
No,
also. One kotha, my
it
lord,
is your land. Your land, they are not going to alienate the land. You do not have a case for privacy case. We'll issue notice.
but my lord, that land also, my lord, the other portion
When you
land,
want to sell, you will sell it if it is your land, but not now.
my lord, for a time being, because my
No,
lord,
no.
irreparable loss, that principle is not applicable.
No.
Irreparable loss.
I'll pass a speaking order then. See, I'm asking, I'll issue notice.
Yes.
You
Then
want
your
me to
lordship-
pass a speaking order, then it will go against you.
No, your lordship may issue notice, my
I'll
lord.
issue notice.
An interim prayer may be considered after.
Yes, that is what I was suggesting.
Yes.
Our learned counsel, Mr. B. Borua,
Madam.
for the petitioner, Srimati Mirla Gogoi Ahmed and petitioners, no?
Petitioners, two, madam.
No, only one petitioner.
There is
Okay.
two
For the
petitioners.
petitioners, Srimati Mirla Gogoi Ahmed and Abdul Hassan Rufiq Ahmed, full stop. Petitioners to take steps to issue notice to the respondent. Meanwhile, call for the scanned copies of the records of Mizje case number 150 of 2023 and title suit number 95 of 2023. The prayer for interim stay will be considered on returnable date. This is the matter of 9 January.
9.
Issue notice to respondents, Nikhil, no?
Obliged, madam.
Item 38. Hearing के लिए दिसे, hearing के लिए दिसा है. Motion on limit.
Please, I filed my additional affidavit, lordship, probably that has not come to its record.
Oh, it
I
has
have
not
the
come when you
exact-
come after some time then?
Lordship, yes, and lordship, the thing is that on last occasion, lordship, I was supposed to file additional affidavit, accordingly I have filed it. Now registry is lordship insisting that in the last line of your last order, lordship may kindly have last order. In the first line, lordship was exactly right that.
Okay, that.
Now they are saying that it should have been IA, so I have filed additional affidavit. Normally, lordship, to bring on record some extra document, we file additional affidavit. So hurriedly, lordship, I filed this affidavit yesterday. Lordship, that may be in call for lodge. Otherwise, registry.
We have called, it's not here.
Yes, but the registry is saying that it should have been IA, so how can we send it on report since there is IA?
You file an IA till 99 here only. You file an IA. Actually, they have to.
Because it is additional.
The intricacies of the rules.
Yes.
I'll have to check because I'll also have to read the rules. So instead of me reading the rules, the
No, no,
ST is
it's fine.
conversant with the rules.
It's fine.
You file an IA if required.
If, otherwise, if Lordship allow me to,
If it will come, we have called for it. If it will come, then we take it up.
okay,
That's
I'll
it.
try to
Yeah,
talk with
that's
my
it.
registry laws.
But they are more conversant with the rules
Yes,
because
yes.
they are dealing every day.
Yes, that's true.
And we keep forgetting, and then
Got it.
we sometimes I don't know also many.
Normally, Lordship.
Because I have read only a few pages, required pages I have read, others I have not read.
Lordship.
So you see,
So if they
this,
allow it,
this I'm not very much
Yes.
aware of. Have we come up to sometime?
Lordship. Obliged.
I can write or at least.
As per last order, your lordship, it was directed that the matter be listed in due course. After hearing the matter, the court directed that it should be listed in due course. Due course means serially it should have come, but suddenly it has
It
come.
has come.
Last order lordship may prevail.
Yes, yes. We'll list it there.
Yes.
Petitioner is also not here. List this matter in due course. As per usual process.
Right.
Item 6. Ele did say no, come, how heavy you have said.
Wait. Well, here I have Selene, the order dated 21/11/2023, as well as the order dated 6/12/2023. Basically, on the ground that in the main suit, the learned trial court below has sent the order dated 21/11/23 to the Lot Mandal as well as to other concerned persons, and subsequently by the order dated 6/12/2023, the report of the commissioner has been accepted, whereas in the suit on any day, my lord, the advocate commissioner was either appointed or he was instructed to do any particular end. So without appointment of the commissioner, my lord, whether the learned court below has accepted the report of the commissioner, this is the vital question to be decided herein, my lord. Now, my lord, lordship may take note of the order dated 21/11/2023. Prior to that, lordship may take note of the page 40, my lord. Page 40 is the, my lord, entire order sheet, my lord.
Okay, all the order sheets
My lord.
from page 40 onwards.
Page
And the
40.
impugn order is page 76.
My lord, yes, my lord.
Okay,
Now, my lord.
you want to show that the commissioner was not appointed.
Not appointed, not at all appointed, my lord. Even, my lord, what happened, my lord, without giving me an opportunity to cross-examine, my lord, the report has been accepted, my lord.
Okay, the entire order sheet from 2/6/2023.
My lord. 2/6/23 is the, my lord, very first day. Now, my lord,
You have submitted, you are the defendant.
I am the defendant.
You have submitted written statement.
Yes, my lord, I have denied the allegation, my lord.
Hmm?
I have denied the allegation, my lord. Now, the relevant part of order is at page 46, my lord. 23/8/2023, my lord. Earlier part as regards to my discovery of documents, etc. etc. Now, my lord, both parties are represented. May I read out?
Yes.
Neither of the parties have filed any document, list the matter on 14/9/2023 for framing of issue. Next, on 14/9/2023, both the parties are represented. Plaintiff side has filed list of witnesses. Same be kept in record properly, heard on a counsel of both the parties. List the matter on 22/9/2023 for framing of issue. Now, on 22/9/2023, both the parties are represented, heard both parties. List the matter on 30/10/2023 for framing of issue. Again, 30/10/2023, both the sides are represented by the engaged counsel. Today, this case is posted for framing of issue, heard both the sides.
fixing 21/11/2023 for issues. Now, my lord, impugnation order has come, my lord. On 21/11/2023, both the parties are represented. Today, this matter was listed for framing of issues. Plaintiff side has filed two documents, one original registered sale deed by serial number so-and-so, dated so-and-so, and photography of the disputed land. Same be kept in the record properly. Defendant side has also submitted a list of documents. Same be kept in the record properly. Hard learned counsel for both the parties. List the matter for framing of issue on 6/12/2023. It is made clear that framing of issue would be done in presence of learned counsel for both the parties as per notification of Honorable Guwahati High Court. Courtmaster shall send a copy of this order to the circle officer Harisinga, and the circle officer Harisinga is directed to depute one Latmandal for demarcation of 2 kothas of land. The OC of Tangla Police Station is also directed to depute at least 2 armed force branch constable to accompany the advocate purpose. Order this also sent to the SP Udalguri for necessary action and compliance. So prior to this, my lord, there is no such order whereby any advocate commissioner was appointed or any commissioner appointed in relation to making any inspection or partition or whatever it may be. So court has to first appoint one commissioner, then necessary direction be issued to the commissioner to do the same. That was absent in the mention. But what happened on the next day, my lord, on 6/12, page 15 number. Both the parties are represented. Advocate Commissioner Mr. Samarjit Sharma has filed
Okay,
a
okay, it's okay, yes.
my lord.
What do you have to say?
My lord, in fact, appointed. Kindly come to at page 93. This is in my lord, Miss J case number. Miss J case, my lord. 93, my lord. And he was appointed at page 95. He was appointed, in fact. My lord, let me.
Appointed? Appointed.
My lord, this is the part. My lord. The main shoot was for declaration of right title and interest. An incidental proceeding by way of filing an application under Order 39, Rule 1 and 2. Now, the purpose of how the commissioner has to act it upon and when the commissioner was appointed and in which proceeding the commissioner was appointed, that has to be looked into. The learned trial court below has appointed the commissioner in relation to the injunction petition, my lord, and that too, my lord, for a particular act. That is my lord.
No, it's okay, but that will serve the purpose here also.
No, my lord.
Why not?
My lord, because my lord, Order 23 reflects the commissioner has to be appointed in suit. Miss J case is not a suit, my lord. It is the incidental proceeding of a suit. My lord, next, my lord, I have to point out for what purpose the commissioner was appointed. For what purpose? This is a very vital because Section 75 cannot be, my lord, violated of CPC, my lord. Now, my lord, what purpose the commissioner was appointed? Lord, you may take note of.
So,
My lord, page 95.
just a moment.
Well,
So this supplement incidental proceedings,
my lord.
he has been appointed. So that document that will not serve the purpose of the suit.
No, my lord.
In incidental proceedings, if the order is stayed, the order of stay will not serve the purpose of the suit.
My lord, in that regard, may I submit, my lord? The advocate commissioner was appointed only for a limited purpose to ascertain whether the TINSE is false under the suit land. That has to be ascertained.
He has ascertained.
No, my lord, beyond that, lordship may take note of the order dated 6/12/2020.
Just a moment.
For 2 kothas of land, the learned trial court below has directed the OC so as to demarcate the said portion of land and so as to give it to the plaintiff. But when the relief has been sought for declaration of right title, interest, and recovery of possession, that without making declaration, without going to the trial, my lord, that at the stage of framing of issue, whether the learned trial could below can deliver any
Their position was already delivered.
position was not delivered, my lord, the report was submitted, my lord. That this type of things has been happened. Now, report has to be, my lord, accompanied by evidence, my lord. That was also not there, my lord. And no report was submitted in the injunction petition, my lord. In injunction petition, my lord, no report was submitted. Report was, my lord, accepted in main suit, my lord, which cannot be, my lord. Had it
Let's
been,
see the order. Let's see the order.
my lord,
Huh? Oh, I'll come back after
Fine.
5 minutes.
Wow. Read the order dated 21/11/2023
Which page?
passed in Miss case, my lord.
Yes, yes.
Page 93, my lord.
Page 93.
Page 93 is the order passed in Miss J
Okay,
case, my lord,
yes,
where
yes.
advocate commissioner was appointed. Petitioner is represented by learned counsel, Mr. So-and-so, assisted by Mr. So-and-so. Opposite party is represented by Mr. So-and-so, assisted by Mr. So-and-so. Today, this matter was listed for hearing on granting of ad interim injunction granted in favor of the petitioner. This court passed an order dated so-and-so in which this court granted ad interim temporary injunction directing the opposite parties, their agents, workers, and other family members were prevented from entering into the suit land, and further directing the opposite parties, their agents, workers, and other family members not to cause any damage to suit land in question. When the opposite party number 1 and 2 filed written objection, and while filing the written objection, they have mentioned the schedule of land as a plot of land bearing tag number so-and-so and 46 and PP number so-and-so, measuring 13 lesser situated Tongla town, ward number 2 under Dokwa Moja, Orisinga Revenue Circle in the district of Udalguri, Assam. But schedule of the boundary has not been mentioned in the said written objection filed on behalf of the opposite party number 1 and 2. During the course of hearing, learned counsel Mr. So-and-so for the petitioner has placed one photograph, and the photograph depicts that the opposite parties have planted boundaries by putting pin sale, and has further argued that same has been done after filing of the suit, which has frustrated the injunction order granted by this court. On the other hand, learned counsel Mr. D. Koshunda has argued that the photograph so placed cannot be believed at its face value, and the opposite parties have never ever planted any thin set boundaries in respect to the suit plan. Learned counsel Mr. So-and-so has also argued that the opposite parties who have been in possession of the suit plan has been possessing since 1990, and the opposite parties applied for mutation in the year 2014, but till now the mutation case has still been pending in the office of the circle officer Harsinga. Learned counsel Mr. So-and-so for the opposite has also stated that till now the opposite parties are not aware of as to who is the owner. After hearing learned counsel for both the parties, it appears that in view of the averments made and arguments forwarded, this court deemed it fit and proper that the order passed by the court on 2/6/2023 granting ad interim injunction in favor of the petitioner is hereby made absolute. Learned counsel Mr. T. Moore for the petitioner has stated that as the learned counsel Mr. So-and-so for the opposite has raised objection relating to the photograph so placed on behalf of the petitioner.
Okay, that Mr. Asoma was appointed.
As
I have read it. I have read the order.
As Soma was appointed for a particular act as
I have
to,
read the order. It's okay.
yes, madam. So thereafter, no such report accompanied by evidence was ever submitted in the said Mizze case. Thereafter, Mizze case was disposed of. No report was in fact submitted in the same way the advocate commissioner was appointed.
Okay.
Now, question arises whether the learned trial court below has committed error in accepting the commissioner's report in the main suit where advocate commissioner was never been appointed. That part has to be taken care of. So for the order sheet, I have read of my lord. Nowhere it is mentioned that on any day any advocate commissioner was appointed to a certain particular fact, my lord.
Yes.
Now, so far that part is concerned, my lord. The order which I have, my lord, challenge here in my lord, it is not, my lord, in accordance with the order 26 rule 9, my lord.
Order 26 rule.
9, my lord. My learned brother has stated that advocate commissioner was appointed, and accordingly that report has been, my lord, applicable in this main order. Now, rule 9 says of order 26 that in any suit, this is the vital matter, suit matter, in which the court deems a local investigation to be requisite or proper for the purpose of elucidating any matter in dispute or of ascertaining the market value of any property or the amount of any mean profit or damage or annual net profits, the court may issue commission to such person as it thinks fit, directing him to make such investigation and to report there.
It has to
To
be
the-
a suit according to you,
My lord,
not a miscase.
miscase is an incidental proceeding of a suit.
Yes, it is incidental proceeding. Yes.
So, my lord, in main suit, my lord, no advocate commissioner was
Not
appointed.
appointed, okay.
Order 26 confines to that, my lord. So, since no advocate commissioner was appointed, whether the report which ought to have been filed in the miscase
Miscase.
can be accepted in the main suit. This is the vital question. Let the matter be admitted. Let my brother sir submit in the main hearing, my lord. And the record sheet, dear madam, if your lordship needs the entire order sheet of misjay case, I can produce through additional affidavit for proper effect adjudication of this matter, madam, so that no party shall be deprived from getting justice.
It was almost settled only between the parties.
Madam, no-
Quarters of land has already been handed over.
No, my lord. That was although reflected, my lord, that was never been executed.
They have in fact,
See, I agree with you. If there's an order in a miscase, then miscase after disposal, it will have effect on that order.
Right. I want to, my lord, bring entire order sheet of
After
misjay case.
disposal of the miscase, it will have an effect on the suit.
No, so after
That
the
the miscase has to be disposed of in its own capacity.
miscase,
I agree with you on that
Right,
point.
right. So let the matter be admitted for fixing for hearing, madam. In the meantime, madam, the entire order sheet of misjay case, I can produce two additional affidavits, madam.
that
And so for
LCR
the
in the
status
form
of-
of has been already received.
No, no. It will not main sheet to receive.
No, I to Mr. Masala.
I have actually.
That is there, Milord, but my humble submission, this may not be admitted and fixed on a hearing date so that on that day it can be disposed of. Because Milord, for last year, they have got the stay, Milord, and their main strategy is to delay the proceeding, Milord, and nothing else.
Without admitting, how can I fix it?
My lord, this is 227, Milord, supervisory, my lord.
Okay, we'll fix it for hearing then.
After vacation, due
Yeah.
vacation.
Stay has already been granted.
Granted, that may be continued, madam. Oblige, your lordship.
Or admission column, Milord, only if it is admitted, Milord, it will
That is up to your lordship.
get delayed, Milord.
It's we'll admit.
But
Or
if
it
ad-
will come in admission column, okay?
Yes.
Okay, we'll fix it in the, for final disposal in the admission column, after we
Leave
get,
it.
okay. Learned counsel, Mr.
M.K. Sharma.
M.
M.K. Sharma.
Learned counsel, Mr. M.K. Sharma is present for the petitioner and learned counsel, Asana. Learned counsel, Mr. S. Sahu is present for the respondent. Please this matter in the admission column for final disposal. On 29 January.
Oblige, Milord.
Made in the month of first week of February, madam.
Can be.
Madam. Oblige, your
Ki bar? Bar, day, ki day.
lordship.
Yes, oblige.
Oblige, your lordship.
With the lordship, it's against lordship a judgment of the commissioner for workman compensation, lordship. So I have given a substantial questions of law. Page number 7, from 7 Lordship.
Page number 7,
Yes, Lordship.
page number 7.
7 of the memo. Is there substantial questions of law on which I have? Basically, question number 2, Lordship.
Question number 2.
2 and also, all these are important also, but 2 and 3 both. No. All of them are yellow, but 2 and 3 can be calculated.
Why do you want this question?
Lordship?
Why do you want this question?
Listen, what has happened is is a part of, in fact, Lordship, a series of appeals are filed
You are for whom?
for the insurance company.
The insurance company.
Yes, sir. It's in fact only one of the many appeals I have filed under one ground, Lordship. It's a very serious issue that has to be
No, that
tackled, Lordship.
earlier part, we can divide your question into 2 parts. The later part, do you need the later part?
Later,
Last line, do you need it?
7 or 8.
Change the line little bit.
Question number 2.
Yes.
Whether in a given place there is a distinct where there is a district medical board duly considered orthopedics. That can be, but only the doctor, he was neither a orthopedic nor a radiologist.
That last line, only last line I'm asking.
Only last one with unsound and unethical. That can be there.
We'll delete it.
Yes, yes.
And then we'll frame the question and then we'll admit.
Lordship, this only Lordship may who is not an orthopedic doctor. My suggestion is it's not
that
a
I'll-
sound and unethical practice, not a sound and ethical practice. That's what my. Because what will happen in this case, Lordship?
We'll delete
The doctor himself has admitted, Lordship, that he has signed a report of an external laboratory which is not his own. He has admitted here that this laboratory is not mine, but he signs on his own page that here. And Lordship, this is various. I've listed out various irregularities.
That ethical, unethical word will delete, then rest will.
Yes, unsound medical practice. That just by deletion of that.
And 3 also you want?
3 also, Lordship.
Anything else?
No. And also deposit 50% for getting that stay.
How much you have to deposit? 50%, no?
I mean, deposit 50% for the stay order.
What is the total compensation awarded?
2,32,054.
Okay. And this claimant,
Yes.
was he an employee under any government or?
No, he is an
private?
employee of the vehicle.
Oh, he was the
Employee.
employee.
That's it has come into picture because there's an road
Workers'
accident.
compensation.
Yes.
Under which department?
It comes under the worksman employees.
No,
the
under which
labor
department,
department.
huh? Labor. No, this employee under, he is employee of which
Of a vehicle, Lordship. He's a private vehicle.
private vehicle?
Private vehicle.
All right, 1 and 2. Heard learned counsel Mr. R. Goswami for the insurance company. Name of the company?
National Insurance Company, Lordship.
For the National Insurance Company, who is aggrieved by the judgment and order dated
22/10/2024.
22/10/2024, no?
Yes, Lordship.
Passed by the Learned Commissioner.
Borpeta. For the employees compensation.
Learned Commissioner, Employees Compensation, Borpeta. Awarding a compensation of rupees 2 lakhs, how much?
32,000. 054.
32,054 to the claimant who was a driver,
He was a driver.
who was employed as a driver, full stop. It appears that the appeal may be admitted thus. This appeal is admitted on the following substantial question of law, page 7 of Java, 2, 3 to likhi diba, into 1, 2 boli likhi diba, huh? Unethical word to authorize diba. Number 2 মই mark কৰি দিছো word to underline কৰি দিছো সেই word to authorize দিবা হা 2 or 3 to 1 or 2 কৰি দিলে copy কৰি দিবা page 7 issue notice to the respondent returnable on date of DDO the admitted on the insurer is to deposit 50% of the compensation award. Where do you want to deposit?
In a registry notes.
Okay. How much time is to be given?
4 months. Oh, 4 weeks.
4 weeks. The deposit 50% of the compensation awarded before the registry of this court within 4 weeks from the date of this order. I is for?
I is for that stay loss.
Okay. I to लिख दिया हर दिन स्टार उसमें जाएंगे counsel for the issue notice to the respondents. Okay, list the matter on and the operation of the here we'll issue notice ex parte order will pass or I'll issue notice.
Issue notice. Notice has been sent in the main appeal. They will come notice. And since I have deposited 50%, that notice need not be issued.
Notice need not be issued because you stay order can be passed.
Which is I have.
Which area you are okay to dispose of. Hari tumi enke likhi diba issue notice na lage. The hari বাকি খিনি আগৰখিনি নিচিনাকে লিখি দিবা the operation of the impugned judgment and order award dated আগৰ হে লিখিবা যে appeal to is state subject to the condition is state until further order subject to the condition that the applicant deposits 50% of the compensation awarded to the claimant within 4 weeks before the registry of this court within 4 weeks from the date of this order. In terms of the above observation, this I stands disposed of. Baki hini agar nisna ke appeal to nisna ke likhi diba.
Item 9. Item 9.
Appellant is not represented today. List this matter date of the meeting. Parties are not represented. লিখিব লাগিব নেকি দুটা পার্টি দুটা নাই steps লোৱা নাই but is stating the leading question নাই এইটো notice চাৱা নাই এইটো পাৰ্টি নাম show কৰিছে নেকি cause listed নালাগে অকল appellant is not represented to লিখি লৈ যাব
The lordship. This lordship in this case, this appeal is on the ground of violation of policy condition. I have nothing against the claimant as such. So I'm willing to deposit some money. I'm there's a violation of policy condition. The owner remained absent. No. He did not rebut the denial the condition that the driver did not have a proper deal at the time of the accident. So I'm against against the owner for pay and recovery. So nothing to do with the claimants. So I'll deposit 50%, let the matter be this year. No. He can withdraw also that 50%. He can withdraw that 50%.
my lord, let them deposit 50% and the claimant may be allowed to do.
Yes,
My
in that IA.
In the IA.
Learned Counsel Mr. R. Goswami is present. IAT लिखवा हाँ. IAT she 442
Yes, Lordship.
is present for the Learned Counsel. Mr.
Double
R.
four
Goswami here is present for the insurance company. And Learned Counsel
J.
Mr.
Mullah.
J. Mullah
J. Mullah for respondent 1.
is present for respondent number 1 and 2. Only
One.
one.
Yes.
For respondent number 1. Full stop. Through this application, the insurance company has paid for stay of the operation of the impugned judgment and order dated 29/1/2024 passed by the Learned Commissioner Employees Compensation Borpeta in EC case number 183/2022. আগৰটো case number টো দিয়া নাই দেই employment তুমি চাই পেলাই লিখি দিবা full stop. The prayer for stay is allowed until further orders subject to the condition that the insurance company deposits 50% of the compensation awarded to the claimant. Full stop. The before full stop, comma before the registry of this court within 4 months within 4 weeks from the date of this order. Full stop. On prayer by the Learned Counsel for the respondent number 1, comma. The respondent number 1 is allowed to withdraw the 50% of the awarded amount.
Right.
In terms of the above observation, this application stands disposed of. Eto ako likhita MFA to Learned Counsel Mr. R. Goswami is present for the insurance company and Learned Counsel Mr. J. Mullah is present for the respondent number 1. Full stop. Issue notice to respondent number 2. Call for the we'll call for the records.
Lordship, respondent to notice has been received by him, Lordship. But
In
I can
IA
take it again because it is against him, so I'll take it.
Issue notice to respondent number 2. Then again, we'll call records later.
Yes.
Yes.
So records may be called for, Lordship.
Call for the records of the call for the trial original records of আগৰটোতো লিখি দিলো না of a case number 2. List on 28th January.
Okay.
May I please, Lordship, judgment is passed by the Commissioner Nagaon, my lord. We have already framed 3 substantial questions of law, my lord. It is in the first phase, my lord. Whether the appellant insurance company has liability to case since the deceased Mustafa Ahmad did not die in course of employment. And second is the Learned Commission committed mistake calculating the compensation, my lord.
Your caveat?
No, your lordship, earlier delay was there. Delay was
Delay
conducted.
already conducted.
You have any objection on the 2 substantive?
No, my lord.
Let the appeal admit it.
Admit, my lord.
R. Sharma, no?
L.
L.
Lakshmi
Sharma, Learned Counsel for the insurance company. What is the name of your company?
National Insurance, my lord.
National Insurance Company is present.
Yes,
Learned Counsel, Mr.
1, 2, 3, and 4.
Yes.
for the claimants.
All the claimants.
Claimants
Learned
responded.
Counsel, Mr. D. Mondal, no?
Yes.
Is present for all the respondents, respondent number 1, 2, 3, and 4. 3 also?
Yes,
3,
my
4.
lord.
3, 4.
1 to 4, my lord.
1 to 4.
All the claimants, my lord.
Only 5 will remain.
This appeal is admitted on the following substantial questions of law. Which page?
My lord, we have first, in first page, my lord. Starting page.
Before grounds का बोलो ना.
Grounds को पहले ही बता दिया.
The index.
That you have not given any extra suggestion. So from the grounds, I will.
Yes, go from.
Which ground?
My lord, grounds, my lord.
Separate sheet has been.
Separate sheet has to be given, my lord, in
On the
before index, my lord.
before index.
MFA, yes, my lord.
Before index?
Yes, my lord. We have already.
Oh, yes, yes.
annexed, yeah.
All the three? I'll add all the three?
Yes, my lord.
Okay. এইটো হেৰি মই টাইপ কৰি দিছো হা সাবজেকশন কোৱেশ্চন অফ ল বুলি এখন সেপাৰেট শীট দি থোৱা আছে notices have been accepted by the respondents extra copies to be furnished call for the records of case number what
Case number, my lord, 20 of 2022, my lord.
20 oblique NEC 20 oblique 2022
EC Nagaon, my lord. WC case number.
from the EC Nagaon.
EC Nagaon, my lord. My lord,
Based on
LCR may call for any.
I to limitation হে আছিলে
No, your lordship.
I hear they,
Stay
I
for
suppose
stay.
stay, my lord. We are going to deposit 50%.
you have any objection
Subject to deposit of 50.
okay Lord counsel Miss Elsome is present for the insurance company what is the name of the company
National Insurance Company.
for the national insurance company and learned counsel Mr. D Mondal is present for the respondent number 1 2 3 4 not 5 no
No,
my
5
lord.
is the owner.
Five is the owner, my lord.
the learned counsel for the insurance company has prayed for stay of the operation of the impugned order dated 30/11/2022 in NEC case number 20 of 2022 as the insurance company is aggrieved by the aforementioned judgment and order full stop. The operation of the impugned judgment and order is stayed until further order subject to the condition that the insurance company deposits 50% of the compensation awarded to the claimants. Full stop, the compensation, the 50, full stop, 50% of the compensation may be deposited before the registry of this court.
Yes.
Yes.
Before the registry of this court within 4 days from today. And on prayer by the learned counsel for the respondent number 1 to 4, comma,
By producing some bonds, my lord. Yeah.
it is allowed no, it is allowed, no, Kati. The claimants are allowed to withdraw the
Amount.
deposited amount from the registry of this court on proper verification by the registry.
And
Registry will
producing some bonds, my lord, there.
and also on execution of bonds by the
Claimants.
LCR may call for, my lord.
In the main appeal.
Main case,
Yes, ma'am.
LCR to- in terms of the above observation, the suppositions can.
Highly obliged.
Item 12. May I please your lordship? Lordship, I appeared for the claimant's appellant. Lordship, we prefer this appeals for enhancement against the order dated.
We'll admit it.
Lordship,
Enhancement.
Enhancement.
We'll admit it.
Lordship.
And you'll issue notice to respondents, we'll call for our records. Learned counsel, Mr.
A.U. Ahmed.
A.U. Ahmed is present for the appellants who are aggrieved by the judgment and order dated
17/9/25.
17/9/2025, as they are not, as they are highly aggrieved by the quantum of compensation awarded to them, who some issue notice to the respondents returnable on call for the records of MSC case number. এইটো এৱাৰ্ডৰ যেতিয়া এগ্ৰিভ দিছিলা যে সেইটো MSC কেছ নাম্বাৰটো লিখি দিলা দেই পাছ বাই দ্য লাৰ্নেড মেম্বাৰ লাৰ্নেড মেম্বাৰ of the MSCT, huh? Member MSCT. Or area last of Nikita call for the records of the MSC case number 83 of 2024 list the matter on 4 February.
Obliged.
Item 39.
May please, your lordship. Lordship, may I pray for taking up this matter at 2 p.m. Mr. T.U. Loskar requested me.
Okay.
And
At 2 p.m.
Your lordship may remember that cancer patient for that I was present for quashing for quashing, and your lordship wanted to know whether during quashing there is a Supreme Court judgment to go through the FIR and all this.
I forgot, cannot remember.
Lordship,
You'll
then
have
at
to
2
refresh my memory again.
Lordship, at 2
Totally
PM.
forgotten.
At 2
Maybe if noted, then noted, something is noted.
Lordship.
I'll recall after you
Lordship.
refresh my memory.
I'll-
I'll be able to recall.
Oblate.
13 to 38.
May I please? The record has come, Lordship. Yeah, Lordship, just it is an additional affidavit I have annexed, Lordship, sent it.
I forgot your story.
Yes.
This is
This
additional
title
memory.
suit was filed in long back in 2008. 2008 Lordship, title suit was filed by the present respondent, and it was decreed expiry, Lordship, in 2010.
Okay.
Lordship. Thereafter, Lordship, they processed for execution of the said decree, Lordship, and accordingly, execution process was initiated, Lordship. The title execution number 8 of 2010. During the Lordship said proceeding, the decree holder and judgment debtor, they have entered into some agreement, Lordship, because they have already sold out the land by this plaintiff, the plaintiff side. Now, in the said execution proceeding, Lordship, this decree holder has filed an application. Lordship will have it at page 47 of my revision petition. Page 47, Lordship. This decree holder, Karna Kasari, has submitted this application, praying before the Honorable Court, Lordship, to relinquish his right over the said decreed land. Swearing, Lordship, in affidavit also. So thereafter, Lordship, this process was, on that day it was halted, Lordship, because since they have entered into some mutual understanding and the application was also filed. So since then, Lordship, this legal heirs of this plaintiff and defendant were, Lordship, still residing there. Now in 2022, after the demises of this plaintiff, that decree holder, their legal heirs come, Lordship, to revive the same execution proceeding by filing application, and now it has been, Lordship, again initiated. Lordship will have the
That page 47, what is this?
This is yes, sir.
What is this page 47?
Yes. May I read the final, Lordship?
Yes.
মই শ্ৰী শপতকাৰী ডিক্ৰীডাৰ শ্ৰী কৰ্ণ কাছাৰী son of পিতা আংখাল বড়ো আং ইকৰাবিল মৌজা ডেফেলি থানা তামুলপুৰ জিলা বাক্সা অসম মই ধৰ্মত প্ৰতিকা কৰি যাওঁ যে মই শ্ৰী বাবুল মণ্ডল গৈৰহৰ ওচৰত এই ডিক্ৰী জাৰি মোকৰ্দমা দাখিল কৰা হৈছিল এই কথা মোৰ জ্ঞান বিশ্বাস সত্য মই ধৰ্মত প্ৰতিকা কৰি কওঁ যে দৰখাস্তৰ উল্লেখ কৰা তফচিলৰ জমি ডেণ্ডাৰ নাম্বাৰ 1 বাবুল মণ্ডল গোবিন্দ বিশ্বাস প্ৰমোদ সিং সুধীন্দ্ৰ সিঙক মুঠ 5 বিঘা 1 কঠা 14 জমি ডিক্ৰীপ্ৰাপ্ত জমি এৰি দিয়া সূত্ৰে এই মোকৰ্দমাত আপোচ মীমাংসা হল এই কথা মোৰ জ্ঞান বিশ্বাস মতে সত্য ধৰ্ম প্ৰতিকা কৰি কওঁ যে এই শপতপত্ৰত শপতকাৰীয়ে উল্লেখ কৰা ডেণ্ডাৰসকলৰ লগত উক্ত ডিক্ৰীকাৰী মোকৰ্দমাৰ আপোচ মীমাংসা হৈছে তাৰ প্ৰমাণ যোগে এই শপতনামা ব্যৱস্থা কৰা হ'ব নেক্সট পেজ আছে যে এফিডেভিট পেজ 48 is the affidavit.
1 বিঘা 2 কঠা 10 লোচা
5 বিঘা 1 কঠা 14 লোচা This is the only one application.
দয়া পুত্ৰে যেনে শ্ৰী বাবুল মণ্ডলক
Yes.
1 বিঘা
1 বিঘা 2 কঠা 10 লেচা গোবিন্দ বিশ্বাসক 7 লেচা প্ৰমোদ সিং 1 কঠা 15 লেচা আৰু সুধীন্দ্ৰ সিংক 3 বিঘা 2 কঠা 2 লেচা
মুঠ 5 বিঘা 14 লোচা
Yes. 5 বিঘা 1 কঠা 14 লেচা
Okay, 5 বিঘা 1 কঠা 14 লোচা
So this is only one application. In other aspect also, Lordship, they have filed separate application, relinquish their right to Lordship regarding the decreed land. Now after 10 years, Lordship, they have again Lordship revived the execution proceeding since there was a decree. And this person also, Lordship, their Lordship, does cultivators, some are Lordship working in the mines, Lordship, near Bhutan area. So they have no idea about this proceeding. Now initially, Lordship, suddenly they have received this notice of this honorable court, and by order dated 15/11/25, starting from page 51 of my petition, Lordship. By this executing court has Lordship directed the concerned na civil na je, to lordship hand over the change decretal land. Now lordship the this petitioner, there is a lordship, they are residing like a village lordship. It's area big area, around 42 acres land is there. So many families are residing lordship after mutual understanding in the decretal proceeding. Now, therefore, also I have annexed this document in my additional affidavit, the sale deed, which was also executed by this decree holder himself, Colonel Kasari. So all these sale deeds are there, but they are not aware that, let's say, after executing the sale deed, they have to mutate their name, they have to correct the land record, they have no knowledge about it. So now I have instructed my client also that since you have this sale deeds, you can approach that executing court also that this land was sold to us. And in between this execution proceeding 2010 itself, some mutual understanding was there according to the application was filed. So all this lordship, it will take few days lordship. So that is why I'm praying to accommodate few days so that I can approach the executing court that this is the situation. In 2010, this situation was happened and this petition was filed. That is my prayer lordship.
Okay. You are Duzen Singh, Satendra Babul Mondal, Prakash Singh, Sifali Singh, but you see that Sifali Singh
is the daughter of lordship, that's what I'm saying. Sefali is the daughter of Vinod Singh, that
page 47, huh?
defendant number 6.
Huh?
She is the daughter of defendant number 6.
Okay.
Defendant number 2.
Third learned counsel, Mr. J. Kolita, for the appellants. Petitioners, not CRP.
Petition.
For the petitioners who have filed this application against the order dated
15/11.
Huh?
15/11/25, page 51.
Order dated 15/11/2025 entitled execution case number 6 of 2022. So it is submitted on behalf of the petitioners that a title suit was brought up by the petitioners, no?
By the defendant.
A title
respondent.
A title suit was brought up by the defendants, respondents against the petitioners in the year 2008. Full stop. An ex parte decree was passed in the year 2010. And after the decree was passed, there was a mutual settlement between both the parties. Annexure, where is the
Lordship, Annexure 3 is the application submitted by the lordship decree holder.
Page 47 is not Annexure 3.
Yes, that is a vernacular and this is a type. Vernacular is 47.
Page 47?
Yes. It was on 27th of July.
This is Annexure what?
Annexure in
Annexure 3, okay.
Yes.
Okay. Annexure 3 is the application, no?
Yes. Relinquishes a right over decretal land loss.
Application of the respondent Corno Kosari
Lordship.
In title execution number 8 of 2010, relinquishing his rights over the suit land.
Lordship.
Then what happened to the after this was executed?
After it was lying that same position since they did not pursue the case because mutual understanding was there. So the earlier lordship, this plaintiff and defendant, they amicably settled, they were settled there. Now they have died. Both the plaintiff and defendant died.
As the matter was amicably settled, the parties did not pursue the title execution case. And meanwhile, who was the plaintiff?
Corno Kasari.
Huh?
Corno Kasari is a plaintiff.
Both the plaintiff Corno Kasari and but you have
Yes.
a party. He has died.
He has died.
But you have arrayed him as a party.
But now I have come to know that he has died. Because in the
meanwhile, both the plaintiff Corno Kasari and the defendants, which defendant has died?
Defendant also lost. Defendant number 7 has died. Now his son has come to petition number.
What is the name?
Govinda Biswas.
And the defendant, number 7, Gajendra
Govinda Biswas
Govinda Biswas
lost his
have passed away.
and Pramod Singh also.
Govinda Biswas and
Pramod
Pramod Singh have passed away. Full stop. Meanwhile, the legal heirs of the respondents
Plaintiff, yes.
of the respondents have filed the title execution case number 6 of 2022 in relation to the same suit land,
Gotcha.
which was disposed of by TS number
8, yes, number 51 of 2008.
TS number 51 of 2008, and which was amicably settled in TX number 8 of 2010.
10.
Full stop. Through an additional affidavit, the sale deeds executed by the earlier defendants are also annexed as Annexure 5 series. Full stop. I have considered the submission on behalf of the plaintiffs. I have considered submission of the learned counsel for the plaintiffs. It is submitted that although the suit land was under their possession and ownership, the names of the plaintiffs as well as the present appellants and present petitioners have not been mutated in the record of rights. Full stop. This resulted in the new registration of the title execution number 8 of
2010.
8 of 2010. It appears that there is a prima facie case to stay the proceedings of title execution number 8 of 2010, at least till the next date of listing. Thereby further proceedings of TX number 8 of
6 of 2022.
Oh, 8 June to Ligila 6 codiation. The proceedings of TX number 6 of 2022 are here 8 of 2010. It just I got 6 of 2022. Is stayed till the next date of listing. Issue notice to the respondents. List the matter on. Call for a scan copies of the TX number
6 of
2022.
Loss. I'm deeply obliged.
Item number 13, Dale hearing of the daily court, please.
My lord, in this case, the lordship called for the FSL report, my lord.
FSL and DNA report has not received, lordship.
Last 6 months, my lord.
Okay, we'll dispose it of.
Otherwise, lordship, I want to state here, lordship, it was
We'll dispose it of. Without FSL in 6 months. We'll
lordship,
dispose it
there
of.
are materials are sufficient.
Yeah, we'll reject the bail.
Lordship.
Yes.
Lordship.
If there are sufficient metals, we'll reject the bail. Let him submit.
Lordship.
My lord, but my submission is that, my lord, the FIR clearly mentioned the name of 2 accused persons, my lord. And incident took place on 13/3, my lord. And FIR lost on 6/3, my lord. My lord, after 4 days, my lord. After 4 days, knowing fully the incident, my lord, they have specifically mentioned the name of 2 accused persons, my lord. But my name has not mentioned in the FIR, my lord. On the 164 statement, the father, in the FIR, my lord, the girl was unconscious, my lord, at the time of incident, my lord. How he make a statement under 164 statement, my lord, that he saw the petitioner at the time of incident, my lord. He just saw the incident, my lord. But name have specifically mentioned in 2 accused person, my lord. My name has not mentioned, my lord.
Okay.
An incident has been took place after 4 days, my lord. And knowing fully the incident, my lord. After 4 days, even they have not named my name in the FIR, my lord.
Lordship, where I have seen that, lordship, the FIR has been lodged by her mother, lordship, and moreover, she was an unconscious state, lordship, when these things have happened.
and I have filed a substantial question of law in paper sheet.
What is this IA for? What is this IA for?
I have for stay of
Okay.
judgment and decree.
Yes.
My lord, crux of the fact is this: the plaintiff here respondent filed this suit in 2015, claiming that the appellant defendant was failed to make payment of rent. And
You
on
are the
that,
plaintiff and you are the plaintiff.
I am the defendant.
You are a defendant.
Defendant.
And now you are the appellant.
Yes,
Okay.
I am the appellant. It is concurrent judgment. Here, your lordship, the plaintiff claim for eviction from the rented house as claim. And on this written statement, the defendant also stated that the defendant was purchased the land in 2000, whereas the plaintiff claimed that he purchased the scheduled land in 2010. And after purchasing that, the defendant was allowed to run his business on rent. And the
According, you have purchased a
Yes.
house.
I have
Now you are not a tenant.
yes, the
Earlier you were a tenant.
no, the defendant appellant here purchased the land in 2000 at a rupees 90. On that situation, that sale deed was not registered. And subsequently, the plaintiff said he purchased the land of measuring 17 lesas, executing a registered deed. And he said that that 1.38 lesas of land also include that 17 lesas of land. This is the dispute. I am not on that 17 lesas, and the plaintiff said that yes, that part also within my schedule. But schedule of the land, which is stated in the plain as well as in the written statement, not similar. Plaintiff said that my land is 8 by 21 feet, and defendant said 8 by 25 feet.
Plaintiff's land is how much?
8 by 21.
And your?
8 by 25. 25.
1 feet.
8 by 25 feet.
25.
Yes.
And
And
yours is,
plaintiff land is 8 by 21 feet. 4 feet difference. Plaintiff claimed he purchased the land by executing registered sale deed. And
you did not have.
I am not, I have
because
not.
It was 90 rupees.
Yes, only 90 rupees, including subsequently, and one tin shed. Tin shed was purchased in another amount of rupees.
Where is the land?
Land is in a town area, Borpeda Road,
And you have a shop.
Borpeda district.
You have a shop there?
Yes, and I have running the shop since 2000.
We'll go to the appellate judgment.
Yes.
main point of discussion, appellate judgment, which
Here, your lordship, it is a concurrent judgment and
it
you
is
could,
not required.
yes,
Concurrent judgment, appellate judgment will work.
yes, yes.
Which page?
Yes, my lord, 50.
Only the main issue. Other issues are not required.
Yes. In the trial court judgment,
No,
only
no,
one-
no, 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 not the trial court judgment. I'm asking the appellate court
Yes.
judgment.
page 54, brief facts of written statement.
Not required. Deep facts are not required.
Page 63. Discussion, decision and reasons for such decisions.
Issue number 1 is not required. You can go to issue number 2, page 65, and you can read it.
Yes.
Otherwise, if I can also read it, you can sit down, I'll read it.
My lord.
I'll read it.
My
You
lord.
sit down. Okay,
My lord.
what substantial question of law? There is no substantial question of law.
Substantial question of law, my lord. It
No.
is a statutory provision if it is rented as claimed by the plaintiff. The statutory provision is this, under non-agricultural,
It's not required to go there. It's not required to go there.
as because, my lord, substantial question of law, which is not decided
No, not required to go there.
without notice, and how much rent was default, and since when, that was not telling in the plain, my lord. Only just said that he is a tenant.
Plain?
My lord,
Where is the plain?
plain, my lord, page.
But you did not prove your ownership over the land.
It is admitted fact, my lord. I have no any document. As because it is
No,
oral person.
Not admitted fact. You have purchased the house for 500 rupees.
Yes.
Then where is the document purchasing the house?
Land without document and a tin shed
Where is the plane? Let me see the plane.
planed at page 7, my lord.
Plane kon silo. This is not
Page 4.
suit
Para
under
4, my lord.
rent control. This is not suit under
Urban area,
RBN's rent control.
Urban area, my lord.
Where? It is a suit for declaration of right, title, interest, and class possession.
Yes. It is.
If you want to pay your, if you want to submit rent receipts and all, it has to be a suit under urban areas rent control. You do not
Claim-
have a substantial question.
Claim of the plaintiff is, my lord, rent.
No.
On the basis
You
of
do not
rent.
invent substantial questions of law. You
And-
take adjournment. You take
My lord,
adjournment. After vacation.
my lord.
Please this matter, learned counsel for the petitioner, Mr. K.
My judgment.
97.
My is 37.
Okay. Kunu nai. This is dismissed. RSC is dismissed.
Item 37 for delivery of judgment.
This is also dismissed.
Okay.
36 is also dismissed.
Item number 39. It's at 2 p.m.
In this case, Lordship.
39, no?
Yes, Lordship.
Yes.
This is a quashing petition, Lordship.
Yes.
And FIR is at page 15, Lordship, Annexure 1.
Page 15, yes.
Lordship. I have the honor to state that on 21/2020, Monday at about 12:30 p.m., the accused persons trespassed into tilla type land in our possession, inherited from our deceased father, situated at Jhum Basti, Shanti Niketan Road, and forcibly cut down the trees and tried to take possession of the land and to put bamboo fencing. When I registered their activities, they tried to beat me and used filthy languages. I did not take action due to the fear of life and breach of public tranquility. It is to be mentioned here that a case is pending before the Honorable High Court in respect of the tilla land, and in the said case, status order is passed. Status quo is passed, Lord. In this case, what happened, Lordship? There is a title suit. Suit was, Lordship, decreed. Thereafter, we filed a title appeal, and we are the defendants there. During pendency of the title appeal was, Lordship, decreed. Then the plaintiff filed a regular second appeal before this Honorable High Court. And thereafter, they take a ground that they want to adduce some document. Then the trial, this second appeal was remanded back for fresh disposal by the first appellate court. Then the first appeal was dismissed. Then we preferred regular second appeal, and the second appeal is pending. During pendency of the regular second appeal, there is a dispute, Lordship. So this FIR was filed by the respondent of the second appeal, and thereafter we have filed, Lordship, the injunction order before the regular second appeal, and status quo was granted by this court. So
This is at admission stage or motion stage?
admission stage.
Okay.
I am praying for disposal of the case only on the ground that one of the petitioner is suffering from cancer.
Oh, yes, yes, now I
Lordship.
remember.
So I fixed this matter yesterday at 2 p.m., but it was listed before court number 40. So I prayed and again it is listed here. We have also filed one FIR. That cross FIR was, GR case was proceeded for trial. Thereafter, the petitioners did not appear before the trial court. That case was dismissed already. And this case, Lordship, charge sheet was filed. The charge sheet is page 20. Second paragraph, Lordship. During investigation, place of occurrence was visited, drawn up sketch map of the place of occurrence, examined the witnesses, recorded their statements under section 161 CRPC. It reveals that the case is found well established under section 447, 427, 294, 34 IPC against accused persons Renubala Ghosh and Leela Saha. These are the two petitioners, Lordship, who were interrogated and released after issue of notice. This Leela Saha is suffering from cancer. So I beg to send them up to face trial before the Honorable Court under the above prosecution sections of law. The witness noted in column 6 will prove the case. They may kindly be summoned. The copy of sketch map, notice copy are enclosed. Thereafter, page 24, annexure 3, Lordship. Case record is received on transfer for disposal from the learned Chief Judicial Magistrate Karimganj. Peruse the case record. It is found that charge sheet has been submitted in under section 447, 427, 294, 34 of IPC against the accused persons are Renubala Ghosh and Leela Saha. On the basis of the materials in the case record, cognizance of offense under section 447, 427, 294, 34 of IPC respectively against said above accused persons are taken. And thereafter, case is going on. After filing of the criminal petition, proceeding was stayed. The entire proceeding was stayed and till disposal of this revision petition, Lordship, criminal petition.
Oh, these proceedings are already stayed.
Yes, Lordship.
So now it has come up for admission.
Yes, Lordship. I am praying for disposal. If your Lordship take up for final disposal on the ground that a civil dispute is pending, Lordship.
Can be taken up. What do you say? It can be taken up for final disposal.
My lord, on
Should I
the
hear the final argument today?
final argument, my lord, the fact is that, my lord, the criminal proceeding that has been pending before the learned trial court has been stayed
It is stayed,
until
yes.
until disposal of the regular second appeal.
Yes,
pending
she is
before his
praying
court.
for disposal today itself. Then if you are willing, then you can place your submission, place your argument.
My lord, the FIR, my lord, that has been filed before the Badarpur PS, alleging inter alia that, my lord, is
Page 15. 15.
page 15, my lord. May I read, my lord?
Yes.
Informant Moran Kumar Ghosh, son of late so and so, accused Renubala Ghosh, wife of so and so, so and so. Sir, I have the honor to state that on so and so date, Monday at about so and so time, the accused person trespassed into the tiller type land in our possession inherited from our deceased father, situated at Jumbasti, Shantiniketan Road, and forcibly cut down the trees and tried to take possession of the land and to put bamboo fencing.
These are all compoundable offenses? No.
Lordship.
Only one is not compoundable.
Not
Oh, that is why it has come here.
Lordship.
That is 294. That is not compoundable, others are compoundable. 294 is obscene acts and song.
Obscene act and songs in public.
Otherwise, these are compounded.
My submission would be, my lord, that I am not disputing the possession. I am not disputing whether I am in possession of the suit land or not. My learned friend has already But the very fact that,
They are for the plaintiffs. You are a defendant.
no, I am the plaintiff, my lord.
You are a
original
plaintiff.
Yes,
You are a plaintiff and they are a defendant.
defendant.
Yes.
I have filed this suit for
Yes.
right title interest and for confirmation of possession. That has been decreed by the learned trial court. Against that, my lord,
preferred an appeal.
appeal dismissed. There is a concurrent finding of fact. Until and unless these concurrent findings, my lord, are set aside by the apex court or by the, it will remain, my lord. It is admitted fact. So, my lord, the civil nature, whatever my friend is submitting, is totally different, my lord. It is not a civil dispute. I am not disputing the possession or status quo order. My lord, the FIR, which prima facie, my lord, involves that there is a criminal trespass, taking possession, cut down the valuable trees. And that's why,
Against that lady who is suffering from cancer, at least against her.
my lord,
Suffering from cancer.
accordingly, my lord, I have filed, my lord, this FIR. Police has investigated, my lord. The
Charge sheet has been
charge sheet has been filed, and on the basis of that, my lord, learned trial court has taken cognizance. So let them try, my lord. This is the fact. This is the submission in a nutshell. It is quite different from that of the civil nature, whatever my friend is submitting.
I have submitted that, Lordship.
Whether there is a prima facie case or not, that should be looked into.
Yes, only prima facie case is
Yes.
required.
Yes.
482, no?
Yes, Lordship. And in the FIR itself, it is stated that we tried to, Lordship, beat them. It is the allegation of the informant that they tried to beat me. So there was no beating by the accused person.
No, see, these are compoundable, huh? These are
Lordship.
compoundable. You see, if he agrees,
Lordship.
except 294,
Lordship.
assault, it will be 352.
Criminal-
Tried to assault.
Lordship.
It is also a form of assault, then it will be 352.
Lordship.
So all these are compoundable. Only 294 is not compoundable.
And-
If they agree, then I can set
And-
aside. But
and
they are not agreeing.
For
This is the
that
problem.
non-compoundable section, Lordship.
Even
only
against the
allegation
lady who
is
is suffering from cancer, if you agree, I will set aside.
use filthy languages, only that much, Lordship.
We have the lower court record, no?
No,
Lower court record 9.
no, Lordship.
There's one judgment, no? You have
Lordship,
to.
that was
You have the judgment.
No, Lordship, I have gone through, but I could not.
It will have no
It was
কোনটো
my Lordship. I have given one judgment on the facts that if
Oh,
civil
PP
suit-
কোন আছে রে? Oh, PP was to give that judgment. I do not have the judgment.
But they have not found also.
Oh.
They also have not found. Earlier, PPPs are there, Lordship. The Vidyut Sharma, I have asked them. She stated that they also have not found them. But although, Lordship, this is a prima facie case has to be established against the civil lawsuits in the.
See, 294, you have to
Lot
say the
that-
exact words uttered, no?
If they agree, they can do that.
Hmm.
Otherwise, two R sections are already.
They are
appointed.
admitting that, Lordship, a civil suit is pending and then regular second appeal is still pending
Sir,
before this court.
Civil suit and
That my learned friend is not objecting, and only status quo order was passed by this court. Those I have already enclosed, Lordship, with my criminal petition. And
He is
moreover,
not
Lordship-
disputing because he is in possession of the land.
Lordship, he is saying
And
he
it's
is in.
an order actually. I can pass an order, but the records.
it is admitted fact that I am in possession.
And there were cross affairs, Lordship.
No, because the CD is also not there. We can go through that only. Lordship. Because otherwise materials are not there. Only CD is there. That also we cannot go through. To look into the whether it has.
Charge sheet is there.
Charge sheet is there. And cognizance has already been taken, Lordship.
Let us call for the record after vacation then. Okay?
Lordship.
CD will be called, need to be called for, Lordship.
Okay.
CD is also need to be called. Can copy of it.
Heard Miss R. Chaudhary, learned counsel for the petitioner, and learned counsel Mr.
TU Laskar for
T.U. Laskar for the respondent number
Two.
two, and learned counsel Mr. K.K. Das for the respondent state. Call for the scan copies of the trial court records, list the matter on.
Lordship, along with the CD, scan of it.
Oh, call for the scan copies of the trial court records along with the scan copies of the CD, huh? List the matter on 8 January.
Lordship, trial court record from additional Chief Judicial Magistrate Karimganj. GR case number 19, page Lordship 24, Annexure 3. GR case number
It's okay,
198.
they will call. I am sure registry will call correctly.
Lordship.
Otherwise, if you give numbers, then they will get confused and they may
But
call
there
for wrong
are cross
records.
cases, Lordship. For that they.
Okay. Call for the
that-
records of which case?
Lordship.
Records. Call for the scan copies of the
Page
trial court
24.
records and scan copies of the CD of
GR case number 198, 2020, PRC 90 of 2023.
arising out of
Arising out
F-
of
FIR number, police case
Lordship.
number.
Badarpur PS case number 26/2020. Obliged.
Date at the
Obliged.
8 January.
Let me show. For the appellant, your lordship, and the appellant number 5 and 1 was died. And we have filed 5 numbers of missed cases, but due to some silly mistake in one, today I have noticed for my declare that there is a silly mistake in one missed case, your lordship, and that is why those are not listed. So after vacation, any day it may be given. And
Which miss case?
missed case relates to appellant number 5 was died, and there is abatement petition missed case IA, and there is delay also, and appellant number, and there is another missed case regarding
408 is listed today, 467 is listed today, and 2701 is listed today. Which one is not listed?
Lordship, may I submit?
so far my
Lordship,
information is-
regarding appellant number 5 for substitution of their legal heirs, 3 petition I was filed in the month of February of 2025. Thereafter, 2 order was passed by this honorable court to rectify them. But last see the office note dated 12/12/2025. Still now, those I was lying in the filing section. They were met no effort to rectify them. Although there is a 2 order by this honorable court, lordship. Lordship, kindly see the order dated 12/2/2025. And in this appeal, concurrent finding is in our favor, but appellant is in a position that's matter is pending from 2012, lingering only to that
Oh, yes.
they are not rectifying them. Lordship, kindly see the order dated 12/8/2025 and 12/11/2025.
there, lordship.
Let me submit. You have not rectified those, despite the order was passed by this honorable court
Today
on
itself,
twice
I have
occasion.
come to know that only one missed case.
No,
is
no,
there
lordship.
mistake.
Kindly see the order dated 12/8/2025. They have filed their
These are not, I think these are not the demerits of. the
what
case,
should be
lordship.
imposed lordship upon them. For this this appeal is pending for 1 year, lordship, from 18 to 2025 and December, today is 16/12/2025, lordship.
They are unintentional, lordship.
Lordship, we have to answer those litigant, lordship. They are watching this proceeding through live streaming, lordship. Only for this appeal is pending for 1 year, lordship.
Really unintentional, lordship. And today itself I can rectify it. After vacation. it will
Lordship,
be-
give a
Please rectify the defects
Okay, yeah.
at
Today
the
itself.
earliest.
lordship, fix the date in the first
Okay.
week of January, lordship.
Any date.
Okay.
Maybe
Learned Counsel, Mr. M. Hussain.
as you say.
S. Hussain is present for the appellants and Learned Counsel, Mr.
A. Hussain, lordship.
A. Hussain is present for the respondents. Full stop. Order dated 12/12/2025 indicates that the interlocutory applications are currently in the filing section awaiting rectification of defects. Full stop. The defects are to be rectified immediately. List this matter
Lordship.
on 7 January.
Lordship.
Lordship, it is mentioned in large sense, lordship. As a large sense, lordship.
To the
Alright.
appellants to rectify the defect.
Item number 16.
Please, Your Lordship. In this matter, only respondent number 6 is appearing. For the other respondent, I could not find the proper address. Lordship, may allow me to take paper publication in respect
Paper
of the
publication.
Lordship.
Learned Counsel, Mr.
K. Jain, Lordship.
A. Jain.
K. Jain.
K. Jain has submitted that notices have been served only to respondent number
6.
6 and the proper address of our respondent number 1 to 5
No,
could not
Lordship,
be.
there are total of 19 respondents total.
And the proper address of other respondents could not be traced. Full stop. The petitioner is allowed to issue notice to what?
Lordship, through
Paper publication.
paper only.
If you notice through paper publication, published through a widely circulated local daily
Law.
of the region.
Much already.
List the matter on 21st January.
Much of.
Wait, please, is your
Yes,
lordship?
yes.
Lordship, as per office note dated 8/12/25,
Mm.
it is mentioned that we have not filed the dusty, but we did file the dusty. So lordship, the registry may verify. And this dusty service affidavit is for service of notice upon respondent number 2 and 3, lordship.
Mm.
1 is appearing.
Respondent number 2 and 3.
Yes,
Respondent number 1 is before us.
yes. So lordship, registry will verify and tag our affidavit with the,
Learned Counsel Ms. R. Muzumdar, no?
yes, lordship.
Is present for the appellants. Full stop. Learned Counsel Mr.
M. Rahman.
M. Rahman is present for respondent number 1. Office note dated 8/12/2025
Yes, lordship.
indicates that notices to respondent number 2 and 3 have not been issued.
But
Through
we already
issued routed to Dusty service. Full stop. On the contrary, Learned Counsel for the appellants has submitted that they have taken steps to issue notice.
No, we have also submitted the affidavit.
Okay.
We have submitted the affidavit also.
Okay, where is it?
No, that is not tagged. The
Okay, okay.
registry has not tagged that.
Oh.
Already affidavit
Has submitted that an affidavit relating to service of notice routed through Dusty service has been filed, which is not tagged along with the record.
Yes.
So registry to tag the affidavit along with this record, list this matter on 6 January.
Hello, blood.
Item number 18.
May I please, Your Lordship?
Mm.
In this case, Your Lordship, respondent number 3 has appeared.
Mm.
And in respect of respondent number 1 and 2, respondent number 1 step we have taken twicely, it has been served. And in respect of respondent number 1, it has been not returned back, Your Lordship. So TCR also received and matter since 2022.
Respondent number 1,
1 and 2,
service is not returned back.
not returned back.
We have to wait.
Lordship, we have taken twicely, and in the main MSCT case, Your Lordship, they have expertise.
Which respondent number 1 and 2?
Owner and driver, Your Lordship.
You want me to delete them?
No, Lordship, their liability also there, so an insurance company also. So, and
Then you have to serve the notice.
Lordship, because TCR also received, so I think it may be further hard and fixed for hearing, Your Lordship. That's the control over.
Without service of notice?
Because main case, they are hard expert here. We have
But
taken twice
if it
the.
is served, then we can proceed expertise. If it is served, then we can proceed expertise.
One sub already, respondent number 1 already sub.
Who is respondent number 2? Owner?
Respondent number 2 is the owner and respondent number 1 is the driver.
Notice has been served on respondent number?
Respondent number 1 already sub, it has been ID has been not been received back.
Okay.
As per the general rules, clause 27, if
You
the
have served through speed post,
register post with ID.
register post with AD.
Yes.
Yes, can be deemed to be served.
No, Lordship.
Have you given the receipt?
No, Lordship.
Then you'll have to give the receipt, then only we can deem it to be served. Is there any order in the office?
Yes, Lordship,
where?
512.
512,
Yes.
that notice has been served?
Respondent number 1.
No, notice has been issued.
Respondent number 1 and 2.
Where, 512?
No, in earlier orders, as per office note dated 512.
Show me the order.
That's what it is.
Respondent number 2, insufficient address.
Yes, Lordship. And 2, 1 not written back. We have taken first step.
কি দিব লাগে আজিকালি স্পিড পোস্ট দিব লাগে না?
Speed post.
This will not work. Address is insufficient.
Insufficient.
You
In
issue
respect of
notice and then you give me postal receipt.
Lordship.
Okay? After 1 month, then we will pass an order for them to be served.
Lordship. Short date maybe. 1 month it will be very long.
What is your name?
SI Akan.
Learned Counsel Mr. S.I. Akan is present for the appellant and Learned Counsel Mr. S. Dotto is
Yes.
present for the respondent number 3.
3.
Office note dated 5/12/2025 indicates that notice could not be served on respondent number 2 as the address was insufficient and AD card of respondent number 1 has not been received back, indicating service report is awaited on respondent number 1, full stop. First steps may be taken to issue notice to respondent number 1 and 2.
Respondent number 2 maybe. Respondent number 1 not returned back till that.
Okay, respondent number 2. First steps may be taken to issue notice to respondent number 2 through proper address. List the matter on.
Sorry.
Item 19.
May I please, Your Lordship? Lordship, as per the last office note, Lordship, 2/6/2023, sorry, Lordship, 22/7/2025, Your Lordship. Service in respect of 10, 12, 16, and 17, 18, 24, 25 has been complete, Your Lordship. And 13 and 22 expire. And 23 adhesive move, Your Lordship. And in respect of to 1 to 4, 5, 6, 7, 8, 9, 11, 14, 15, 19, 20, 21, and 26. I awaited, Your Lordship. So can allow me to 4 weeks time to take first step upon the remaining respondents. And in regarding that to 13 and 22 already expired. Let me have the instruction whether they have the IOSH.
Learned Counsel Mr.
T. Gogoi, Your Lordship.
T. Gogoi is present on behalf of Learned Senior Counsel.
Yes, Lordship.
Mr. T.J. Mohanta, and has submitted that notices have been served to respondent number.
Respondent number 10, 12, 16,
Dikija,
17,
Dikija.
18, 24, and 25.
Mm.
And 13 and 22 expire, Your Lordship.
It is also submitted that office note dated likhi Office note dated 22/7/2025 indicates that respondent number 13 and 22 have passed away, and respondent number 23 has moved from the address. Full stop. The appellants may take steps to file or to issue notice to the remaining respondents and also to obtain instructions relating to deceased respondent number 13 and 22.
13 and 22?
22.
And
This is the
also
matter
have-
you want 4 weeks time.
Yes, Lordship.
This is the matter on 28th January.
Lordship, in the both way, Your Lordship? Steps will be taken both
Yes,
way?
yes. No steps.
Yes, Lordship.
You want to take through speed post
Yes, Lordship.
and dusty service.
No, usual process, Your Lordship.
The petitioner appellant may take steps through usual process as well as through dusty service.
No, Lordship, speed post, Your Lordship.
Through speed post.
Yes, Lordship. Habla.
Item 20.
May I please, Your Lordship? Your Lordship, we are trying our best to serve notices to them, but they are willfully refusing to accept it. This time, respondent number 1, sister has refused to accept it. Kindly, matter may be fixed for hearing. Kindly, matter may be fixed for hearing.
Respondent number 2 and 3, they willfully refuse to accept.
Yes, Lordship. Even respondent number 1 also, one's sister also refused it, which indicates that they are willfully neglecting to receive it. For a long time, Lordship, we are.
Learned Counsel Miss
Yes, Sheikh.
S. Sheikh is present on behalf of Learned Counsel Mr.
M.U. Mahmood.
Your name is not in the cause list. No, no.
no.
On behalf of Learned Counsel Mr. M. U. Mohammed, the order dated 30/04/2025 reflects that order of the Lawazima Court dated 30/04/2025 reflects that the sisters of respondent number 1 have refused to accept the notice on their brother's behalf. And the process server's notice reflects that the respondent number 2 and 3 have refused to accept the notice, refused to accept their notice, full stop. Office note dated 29/4/2025 reflects that the respondent number 1 was not found at home and the family members refused to accept notice on his behalf. Only 3 respondents?
Yes, Lordship.
As the respondents have willfully refused to accept notice, this case is fixed for, this is appeal.
Yes, Lordship.
Just a moment.
Notice.
3 respondents, no? This appeal was already admitted. This appeal is taken up for hearing. This appeal, which was already admitted, is taken up for hearing.
Okay, yes, ma'am.
This is the matter.
Item 21.
Obliged, Lordship.
May I please, Your Lordship?
Lordship, as per office note dated 6/12/25, no AD card or unserved notice has been returned as yet.
How many respondents?
Sole respondent, Lordship.
One
Other
respondent.
two respondents are staff off already.
Okay. Service report on respondent is awaited. List the matter on
3 weeks.
19 January.
All right.
Item 22.
May it please, Your Honor. Mr. Vijay, statutory appeal under section 96, Lordship. Against the judgment and order dated 16/6/2025 passed by the Court of Civil Judge Senior Division Jorhat. Lordship, I kindly.
All are present today.
They are
Lordship,
caveat.
I am for caveators for all the respondents, Your Honor.
For all the respondents.
Yes.
Okay. Learned Counsel, Mr. will list it for admission then. Learned Counsel, Mr.
P. Borua.
We have, you need the LCRs. Do we have the
Yes.
LCRs?
No, we don't.
We'll call for the LCRs.
Yes.
Lordship, I admit it and call for that.
Okay. It has not been admitted. All right. Any objection?
No.
I'll admit it.
Yes, Your Honor.
What are the
Usual,
questions,
Lordship, this is the
substantive
first
questions
appeal, Your
of
Honor.
law?
The first appeal, Lordship.
Lordship,
First appeal?
First
Yes.
RFA?
RFA.
Okay. We'll admit it. Statutory appeal will admit it. I thought it is RSA. Learned Counsel, Mr.
P. Borua.
P. Burua is present for the appellant. And Learned Counsel, Ms.
Yes, Sodhu.
S. Sudhri is present for the caveators, respondents. Full stop. The appeal is against the judgment and order dated
16/6/2025.
in connection with PS number 36 of 2014 passed by the Learned Civil Judge Senior Division Jorhat. Admit, call for the records, trial court records. List the matter after 4 weeks.
May it please the Lordship. In this matter, Lordship, service complaint TCR also received. So matter may be listed for hearing in usual course.
I pay for the respondent also.
Okay. Learned Counsel, Ms. R. Sudhri is present for the petition, appellant.
Appellant.
Appellant and Learned Counsel, Mr.
AI Ali,
A.I. Ali is present for respondent number.
123.
There are three.
All the respondents.
For all the respondents, as the trial court records are before us and as pleadings are complete, list this matter for hearing.
Usual
Due course,
Lordship. In due course. Lordship.
Hearing in due course.
Obliged.
Obliged.
Item 24.
Please, Your Lordship. The Lordship, in this matter, we have filed a review application.
If you notice,
Yes. Lordship, may I kindly admit and I should allow us to take steps.
you still take self issue notice. Learned Counsel, Mr.
Irang Loba.
A. Wrong.
Irang Loba. IRANGLUB.
On behalf of Learned Counsel, Miss
S.V. Chaudhary.
Mrs. S.B. Chaudhary is present. Notice to be issued to respondent.
Yep.
List after 3 weeks. 25.
Wait, please, Your Honor. For the substitution petition, praying for substitution of the legal heir of respondent number 2 who died during the pendency of this appeal. Now, Your Lordship, during the pendency of the appeal, my learned senior colleague appearing for respondents number 1 and 2 apprised this honorable court that respondent number 2 has expired. And so we have filed this petition, which is in time, which is within time. So I'm sure my learned brother will have no objection if there's only one legal heir who needs to be substituted for respondent number 2. The schedule, Your Lordship will kindly see, that is at page number 10. Page number 10 of my petition, that is the schedule.
Okay. Learned Counsel Mr. D. Bhattacharya is present for the applicant, and Learned Counsel Mr.
R. Boro.
R. Boro.
Boro.
Boro is present for respondent number
1 and 2.
1 and 2, whose submit is submitted that during the pendency of this appeal, the learned counsel for the appeal applicant was apprised by the respondents.
No, we are the appellants. The apprised by the applicant, counsel for the respondents.
Apprised by the learned counsel for the respondent that the respondent number 2 has passed away.
Right.
And his name he may be substituted by his legal heir, whose name is mentioned in the schedule of the application. Full stop. It is submitted that Srimati Labana Gohai is the legal heir of the respondent Horokanto Gohai.
Right.
Full stop. Application is also filed within the period of limitation. Full stop. Prior to substitute the legal heir of respondent number 2 is allowed. The name of Srimati Labana Gohai may be added as a party to the appeal in place of respondent late Horokanto Gohai.
Right.
Okay. In terms of the above observation, this I stands disposed of.
My lord, my friend will appear for respondent number
1 and 2 I can appear.
Not
to my instruction lower even.
Otherwise, notice will have to go, but if he has instruction to appear, then
Lordship, I have to
We'll
take
fix this
instruction.
we'll fix this on a date, then it will come up,
Lordship.
then he,
That's
and then he will appear if he will appear.
Right. main appeal is already appeared.
RSL Likhiriba list this matter on data reduction. On 20 January. Okay.
Right.
obliged, Your Lord.
Item 26.
Lordship, respondent number 2 has expired. As such, we have filed substitution petition. However, in filing the substitution petition, there has been a delay of 1,925 days.
So we have two applications. One is delay and one is substitution.
For setting aside abatement and another substitution.
applications.
Three IS. Lordship.
Application three, no? We'll start serially, okay?
Lordship.
We'll start from setting aside abatement.
Your Lordship, in case there is delay, Your Lordship, let a notice may be issued, Your Lordship.
Huh?
Notice may be issued, Your Lordship, the legal heirs of number 2.
Alright.
Because we do not have any wakalat nama.
Okay. I didn't think you had objection, so the deal, not at all, we'll have to issue notice then.
Yes, Lordship.
Then it will come up.
Lordship.
Learned Counsel, Mr.
A Singh, Lordship.
A. Singh, Harry, which is the delay condemnation application? Is present for the applicant.
1096.
1096 please. Learned Counsel, Mr.
S. Diffusa, Your Lordship.
S.
Diffusa.
Diffusa is present for respondent number
13456
1, 3, 4, 5, 6, and 7. Issue notice to
Respondent number 2, legal heirs.
the legal heirs of respondent number 2.
Lordship.
Okay. List after 4 weeks.
Yes. Bless you.
Item 27.
In this case, my lord, condemnation allowed, my lord, but another two, my lord, substitution petition and my lord, setting aside abatement, my lord, it has not been disposed, my lord. That's why, my lord, kindly see, my lord, office note dated, my lord, 11/12, my lord.
In which application? 12, okay.
My lord. But condemnation allowed, my lord, also allowed the substitution, my lord. Kindly see, my lord, I am, my lord, dispose, I am, my lord, 1547, my lord.
One?
1547.
Yeah, it is allowed.
Allowed.
Yes.
But the problem is, my lord, the other two, I am, my lord,
Are pending.
my lord. It ought to have been, my lord, disposed, my lord.
Yes.
And in the meantime, my lord, I may be allowed to, my lord, file the amended cost title, my lord.
Any objection?
No, Your Worship.
Learned Counsel Mr. K.R.
K.R.
Patgiri
Patgiri.
is present for the applicant, and Learned Counsel Mr.
I.H. Laskar.
Huh?
I.H. Laskar.
I.S.
Laskar,
I.H. Laskar is present for the respondent number 227.
227.
Respondent number 1.
One, my lord, already died, my lord.
Oh, died.
That's why,
Okay,
my lord.
okay.
Subsequently, my lord, service also complete, my lord. In condonation petition,
It delay to condone her. It no one.
1547.
1547.
47.
47 to 8 condonation. Oh, it is 1548. 1548. This application is filed under Order 22 Rule 9 of the CPC for setting aside the abatement. Full stop. There is no objection from the respondents. On the death of who?
My lord, respondent number 1, my lord.
On the death of
Akbar
respondent
Khan.
number 1, Akbar Khan, no?
Akbar Khan.
This case against him stood abated. Full stop. The case against him stood abated. The prayer of considering the submissions at the bar, the prayer for setting aside the abatement is allowed.
I order dated, my lord, 12/11. I order dated 12/11, my lord, already allowed, my lord.
Already allowed?
Allowed, my lord, it is reflected, my lord, 1547, my lord. One, I had disposed, I am, my lord. But separate order has not passed, my lord.
Was already allowed by the order dated
12/11
12/11/2025
in IA number 1547.
in IA number 1547 of 2025. Yes,
My lord,
the amendment, thereby the amendment duly stands set aside.
my lord.
This application stands disposed of.
Another,
Any other application?
another 199, my lord, IA
199, okay.
substitution.
এইটো এটা লিখিলা ন আৰু এতিয়া 199 টো লিখিলা. Heard Learned Counsel Mr. K.R. Patgiri for the applicants and Learned Counsel Mr.
I.H. Laskar.
I.H. Hussain for the respondent number 227. 227. Full stop. It is submitted that during the pendency of the RSA number
RSA number 18/23.
18/23, the respondent number 1 has passed away. It is thereby prayed that the legal heirs of the respondent number 1, Akbar Khan, may be substituted. The Learned Counsel for the respondent number 225 has no objection. I have considered the submissions at the bar. Considering all aspects, the petition with prayer for substitution of the legal heirs of respondent number 1, namely, which page?
My lord, page 3, my lord.
Page 3.
My lord.
How many?
1A through, my lord, 1F, my lord.
1A by 1F, namely, is allowed.
My lord, I may be allowed to, my lord, submit the amended cost title. My
The appellants may submit the amended cost title.
lord. Obliged.
Will list the appeal?
My lord, already
Yes,
admitted,
you-
my lord. Hearing, my lord.
Okay.
My lord.
Item 28.
Wait, please, Your Worship. The IA is for condonation of delay. There is a sole respondent and my learned senior sir has appeared, my lord.
156 days.
My lord,
Any objection?
no explanation. Lordship will kindly see the paragraph 2. They have given explanation paragraph 2 and 3, my lord. Nothing has been explained. Initially, they have filed a, my lord, FA
First appeal.
first appeal.
initially they filed a first appeal, on which date they filed a first appeal, on which date it was withdrawn. Nothing explained, my lord. I don't think, my lord, this is the right petition to condone,
With costs,
my lord.
with costs.
It is up to lordship.
On the date when I filed the festival, my lord, that has been mentioned, that is on, my lord, that is on it was withdrawn 27/5, my lord. 19/11/2024, the first appeal was filed, my lord, under wrong perception, my lord. And thereafter, my lord, it was withdrawn, my lord, on 27/5, and on the same date, my lord, 27/5/2025, my lord, this CLP was filed, my lord. Even then, that is, my lord, subject to imposition of cost also, the matter may be admitted.
Learned Counsel, Mr.
A. Ali, my
A. Ali is present for the applicant.
applicant.
I would leave off. And Learned Counsel, Mr. I. Sugya
My lord.
is present for the respondent. Sole respondent.
So respondent.
Full stop. This is an application under section 1, section 5 of the Indian Legislation Act 1963 with prayer for confirmation of delay of 150 days in filing the connected civil revision petition. Full stop. It is submitted on behalf of the applicant that the appellant is agreed by the judgment and decree dated 23/9/2024, passed in connection with TS number 19 of 2019 by the Learned Civil Judge, Senior Division, Gwalpara. Please stop. On 19/11/2024, a first appeal was filed, and under wrong perception, and as the appeal was filed under wrong perception, full stop. It was withdrawn,
My lord.
comma, the same was withdrawn. Subsequently,
This revision petition was filed, my lord, on
The-
27/5.
subsequently,
This petition was, the revision petition was filed.
the present revision petition was
Right.
filed. Full stop. This resulted in the delay. Full stop. Per contra, Learned Counsel for the respondent lays stress in his argument that the delay has not been properly mentioned. Full stop. It is not on the record when the revision, when the petition under wrong perception was filed and when it was withdrawn. Full stop. Sufficient grounds have not been shown and the petition is liable to be dismissed. I have considered the submissions at the bar with circumspection. Full stop. It appears that sufficient grounds have been sufficient reasons have been assigned by the petitioner. Full stop. It appears that there was no mala fide on the part of the petitioner nor the applicant. On the part of the applicant, full stop. No inaction is discernible. Full stop. It appears that delay may be condoned, thereby delay of 156 days in filing the connected revision petition is condoned subject to the payment of cost of ₹500.
My lord.
Okay,
My lord.
to be paid to the other party, respondent.
My. Obliged.
Item 29.
Lordship, may direct the registry to register the, my lord, CRP, my lord, and
Yeah,
fix a
to
date.
register the connected civil division petition.
Fix a date, my lord. for the-
No. Registry will fix.
Obliged.
29.
May I have please, Lordship?
Hmm.
Lordship, this is a delay condonation petition.
Issue notice.
We have already
Other side
taken.
is not present.
Lordship,
Notice have been
notice is could not receive, issued, Lordship. So my prayer is, Lordship, sometime to
Okay, learned counsel for the.
submit proper legible copies of
Yes,
petition, Lordship.
has, is present and has submitted that he will take fresh steps.
Just, I will submit proper eligible copies, Lordship.
That he will submit proper legible copies for, to proceed with the steps taken against the respondents. Please, Dr. on. 27 January.
Oblation.
Item 30.
May it please your Lordship, the office notice that we haven't taken step, but that is not a fact, Lordship. We haven't taken step by postal as well as Talabana. And that is why the respondent number 1 to 3 has appeared, Lordship, the claimants. So Lordship may direct registry to ascertain, give a report on the service. Office note dated 5/8/25.
In I.
In I, Lordship, 2195 of 2025.
Learned counsel Mr. R.D. Muzumdar is present for the applicant. Full stop. It is submitted that it has been wrongly mentioned in the office note dated 5/8/2025. The steps have not been taken as the applicant has already taken steps to register post.
As well as this the usual process.
As well as to.
But it was
usual
taken
process,
in November, September.
as well as to usual process in the month of September 2025. Full stop. What was your submission? Registry to?
And Lordship, registry will give a report on service.
Registry will give a report on service of notice. List the matter after 4 weeks?
Yes. Obliged. Lordship.
Item 31.
May I please, Lordship? Lordship, this is IA. This IA is for coordination of delay. The delay is of 354 days. Lordship, notice may be issued.
Learned counsel Miss?
Miss J. Hendick.
J. Hendick is present for the applicant. Post of notices may be taken to, notices may be issued to respondent number.
Sole respondent.
To the respondent, list after 4 weeks. It
But,
will vary,
Your
IA number
Lordship.
3138, huh?
Item 32.
May it please your Lordship. My lord, kindly have a look at IA 3709.
Can this matter may be taken after vacation, my lord? But my name was not shown in the cause list, so there was some confusion, man.
Okay. Yeah.
Any day after vacation?
Can be.
My lord, problem is, my lord, this honorable court on second appeal admitted on 15th of September 2013, my lord. And they stay till disposal of the second appeal, my lord. In the meantime, despite the stay order, my lord, over the disputed land matter, the permanent instruction constructing, my lord. So we have filed instead I application under order 39 so that they may not violate this order stay order. This is the my lord. So my learned friend, my lord, is here, my lord, to comply, they strictly comply the order passed by this honorable court. This is the order, my lord. Not much, my lord. So
I'll have to take instruction whether he is actually constructing or not, because that.
Well, NXRC I have enclosed. His appearance also very genuine, my lord. I should not object it, my lord. It's clear since his name is not showing, my lord. But, my lord, in the NXRC page 14, can you have a look in the IA, my lord? NXRC page 14, my lord. Page 14, my lord, NXRC. This is the structure of constructing, my lord, permanent structure. This is, therefore, we have come again, my lord, in violation of this code. Okay, my lord. Time may be
Or
fixed,
maybe
my lord.
after before vacation, any day tomorrow.
No, not before, my lord. Huh?
I won't be able to accommodate before vacation.
Yes, my
If
lord.
there is some
Learned
urgency,
counsel Mr.
it might
P.K. Rekha is present.
7th of January.
And learned counsel Mr. K. S. S. Das is present. For the P.K. Deka is present for the applicant, and learned counsel Mr. S. Das is present for the respondent, and has submitted that and has paid for time, as he was not aware of the matter, as his name is not reflected in the cause list. List the matter on 7 January.
Well, my name may be reflected, my lord. Full name,
Please
Surajit Das.
reflect the name of
Surajit Das.
learned counsel Mr. S. Das in the cause list.
My full name, my lord.
Surajit Das,
My lord, 7th of January, my lord.
7th of January.
Deep proposed.
Hello.
Perhaps not in this matter. And for the respondent, madam. The petitioner has filed a transfer petition for transfer of a divorce case of Sri Bhumi, Karimganj, madam. And they have obtained the stay, and I has been filed for vacating the stay. So, my lord,
Lordship, before they submit, Lordship, the copy has not been served to us, Lordship, because the problem is B. Chaudhary. There is other B. Chaudhary's, probably they have served the
then
copy.
yes, my lord, I will serve, but
I have
in
not
the
received
stay,
that copy.
fix the matter after vacation. Entire matter
First
may
week
be heard, my lord.
of February, Lordship, first week of February.
First of February.
First week of February.
Learned counsel Mr.
S.
Leonard.
Nath.
S.
Nath.
S. Nath is present for the applicant, and learned counsel Mr. B. Chaudhary is present for the respondent, and submitted that he has not received copy of the entire all copy of
Only
the
this,
petition.
Lordship, the I state
This
vacation.
application, full stop, copy to be furnished to learned counsel.
And also
Mr. B.
affidavit, I
Chaudhary.
have also filed the affidavit, objection
This
affidavit.
matter on 3rd February.
3rd February. Will.
Oh, yes.
Obliged.
Hello. 3rd February.
May it please, madam. Madam, this revision has been preferred, madam, against a judgment passed by the Special Tribunal, Land Grabbing Act, madam, 2010. Whereby, madam, the present petitioners, they were directed to give the possession of the suit land unto the respondents, madam. Only the civil liability aspect was discussed upon, and the criminal liability is yet to be tried, madam. So, my lord, will find a judgment at page number, my lord, 48. May I read, my lord? This case, 48, this paragraph number 1, this case is filed under the Assam Land Grabbing Prohibition Act by the petitioner Sri Khogen Hazong against the respondents opposite parties, Sri Dipen Hazong, Sri Omit Hazong, Rajeshri Hazong, and Srimati Bajayanti Hazong, alleging the following. The grandfather of the petitioner, namely Bahan Hazong, purchased the disputed land and possessed his share of land measuring 1 bigha 5 lesas, having 5 lesa of land for root, that is the disputed land, along with co-purchasers, namely late Santa Hazong and late Bokhanta Hazong, and planted some bamboo and nut. The father of the petitioner, being the only legal heir of late Bahan Hazong, became the successor and owner of the said land and possessed the said land, and subsequently after death of the father of the petitioner, he, being the only heir, became the successor and owner of the said land and bounded the disputed land by bamboo fencing. That through registered deed of sale, being deed number 338 dated 31/3/1971, the grandfather of the petitioner, namely Bahan Hazong, son of late Mathur Hazong, to Sri Santa Hazong, and 3 Bokhanta Hazong, both are sons of late Gazir, purchased a plot of land measuring 3 bighas 1 kotha under patta number 38, covered by dark number 279 of village Pokharapara Moza Boko in the district of Kamrup, Assam, from Sri Sosi Mohan Sil, son of late Ananda Sil, by investing equal share of amount, and accordingly they had partitioned the said land equally amongst themselves.
Just a moment, others are waiting for hearing. I don't think we'll be able to complete the hearing.
Our case is small. We are fixed last many days is come first.
But it will come up after vacation, can't help it.
I understood.
We'll fix it after vacation.
I fixed on 8th of January.
It will deduct on 8th of January. কৈ দিলে হৈ গ'ল 8 of January বুলি কেছ নম্বৰ
Case number, item number 40.
40
Item 309.
এইটো দি দিব 8 January
It is a case of 17.
and other case anybody for other cases left over কৈ
Yes, no. 8th of January.
okay
Para 4, after death of the grandfather of the petitioner, father of the petitioner, namely Chandra Hazang, being the only heir of grandfather late Bahan Hazang, became the successor and owner of the disputed land, and accordingly having found the possession, the then circle officer Boko Revenue Circle, order dated 14/10/1993, granted mutation in his name over the said plot of land.
land grabbing এখন দিবচোন দেই আছে নে নাই জানো yes
5. In the year 2011, his father, namely Chandra Hazang, died, leaving behind the petitioner as the only legal heir, and accordingly, after his death, he became the successor and owner of the disputed land, and accordingly, having found his possession, the circle officer Boko Revenue Circle, by order dated 15/6/2015, granted mutation in favor of the petitioner over the disputed land by right of inheritance and paid revenue to the government. 6, the petitioner is a government employee under the railway department working at Guwahati, and so he remained at Guwahati since his appointment and subsequently residing at Banda Colony, Narangi, Pragjyotispur in the district of Kamrup Metro permanently. It is pertinent to mention herein that as he was the only son of his deceased father, namely Chandra Hazang, and as such his father used to reside with him at Guwahati. It is mentioned herein that although he used to remain at Guwahati in respect of the service along with his family members, used to visit the disputed land in every month of every year as and when got time, and enjoyed its fruit without any disturbance from any corner since his predecessors. There are 7. The petitioner has also stated that the grandfather of the petitioner as well as the father of the respondent number 1 purchased land measuring 3 bigha 1 kotha under patta number 38 covered by Dak number 279 of village Pokarapara, Moza Boko in the district of Kamrup, Assam, and Sri Sosri Sil, son of late Ananda Sil, by investing equal share of amount through one registered deed of sale, being deed number 338 dated 31/3/1971, and partition the land equally amongst themselves and possess their respective share, which itself reveals
হেৰি থাকে যে অসমৰ যে হেৰিবোৰ যে থাকে যে প্লেন কালাৰ পেপাৰবোৰ যে থাকে yes এই তেনেকুৱা ধৰণৰ he'll get it it's okay he'll get it
has been positive. Para 8, the petitioner had good relation with the respondents, and accordingly, whenever he went to the disputed land, visited the house of the respondents also in good faith, and asked them to look after the disputed land. 9. Till paragraph 8, my lord, there are two important points. Firstly is that, my lord, the suit land that is measuring 3 bigha 1 kotha, that was purchased jointly by the grandfather of the present respondent and by the father, predecessor interest of the present petitioners, my lord. And secondly, my lord, they have only stated that the land, that the disputed land, it was asked by them, requesting us to look after the suit land, my lord. So our entry at that point of time was legal, my lord. Just for the sake of convenience, my lord, I am repeating. Para 9, in the first week of February 2016, when we went to the disputed land with a view to construct a Teen Sali house and called the respondents on good faith to the disputed land. And whenever he started to discuss regarding the construction of the said house, the respondent number 1 asked him not to construct any kind of house over the disputed land on the ground that the respondents are the possessor as well as the owner of the disputed land, and also threatened him not to visit the disputed land in future, otherwise he will have to face dire consequences. 10. Having seen the sudden misbehavior of the respondents, he became surprised and asked the respondent as to why he used such type of misbehavior. In reply, the respondent asked and threatened them by showing Purki to leave the disputed land, and accordingly, having found no alternative, he came back to his residence situated at Guwahati. On 25/2/2016, he again went to the disputed land, but on that day also, having seen the petitioner, the respondents came out with sharp weapons such as dao, Purki, etc., and threatened to leave the disputed land, and accordingly, having found no alternative, PW went to the office of the circle officer, Boko Revenue Circle, and filed an application with a prayer to measure the boundary of the disputed land on the same day. That is on 25/2/2026. And accordingly, the concerned circle officer issued notice to the respondents as well as to the owners of the adjacent land of the disputed land with the direction to present on the date fixed. That it is pertinent to mention herein that although the owners of the adjacent land of the disputed land were present on the date fixed by the respondent number 1, was not present willingly even after issuing several notices upon him on the date fixed with a view to grab the disputed land. Whenever the lot model as well as the circle officials went to the disputed land on the date fixed for measurement, the boundaries of the disputed land, the respondent number 1 each and every time, having not present, instigated other respondents to use filthy and slang languages upon the lot model and his officials, and accordingly, whenever the lot model with his officials came to the disputed land for measurement and handed over the said land on each and every date, the respondent number 2, 3, and 4 came out with some deadly weapon and obstructed the concerned officials to measure the disputed land and used filthy and slang language, for which the circle officer used notice by so-and-so dated 28/5/2016 to the OC Boko Police Station to present at the office of the circle officer, Boko Revenue Circle, on 11/5/2016 to assist the lot model to measure the disputed land and handed over their possession over their respective share. But on that day also, the respondent number 1 was absent and as such could not do the same, and as such subsequently on 27/5/16 issued notice upon the respondent to appear in the office of the circle officer, Boko Revenue Circle, on 3/6/16, and as such craves the leave of this honorable to court to call for the state request for the interest of justice. Para 13. On 27/5/2016, the circle officer, Boko Revenue Circle, issued notice to the respondent number 1 with a direction to appear before him on 3/6/2016 along with relevant documents of his claim in respect of the disputed land. Although on that day, the respondent number 1 appeared but could not file any connected documents and also could not prove his possession over the disputed land, and accordingly, whenever the circle officer asked the respondent number 1 not to disturb him in respect of his peaceful possession, the greedy respondent number 1, in presence of the circle officer, threatened him not to come again into the disputed land and used filthy and slang language upon him and the circle officer. Having found no alternative, he filed the FIR dated 3/6/2016 at Boko Police Station against the respondent number 1, alleging the above noted facts, and accordingly, case being Boko Police Station case number so-and-so under section 447 of IPC Red section 4 and 5 of the Assam Land Grabbing Act 2010 was registered and arrested the respondent number 1. After registration of the case, the statement of the petitioner was examined on oath on 21/9/2016. The report of the circle officer as called for was received along with certain documents. Notices were issued to the respondents who appeared through the learned advocates. After appearance, the respondent opposite parties had filed a written statement and thereafter issues were framed. The following issues were framed for adjudication. A, whether there is cause of action. B, whether the grandfather of the petitioner, namely Bahan Hazang, along with Santa Hazang and Bokhanta Hazang, purchased a plot of land measuring 3 bigha 1 kotha under Pacha number 38, dark number 279 of village Pokharapara, Moza, Boko in the district of Kamrup, Assam, to registered sale deed being number so-and-so by investing equal share of amount, and whether they have partitioned the said land equally and possess their respective share. C, whether the father of the petitioner, namely Sandra Hazan, got his name mutated over the disputed land on 14/10/1993 by right of inheritance. D, whether the petitioner got his name mutated over the schedule on 15/6/2015 by right of inheritance. E, whether the disputed land is a joint property. F, whether the respondents are the pattadar, joint pattadar of disputed land, and whether respondents are paying land revenue to the government regularly. G, whether the respondents have right, title, interest, and possession over the disputed land, whether the respondents have grabbed the scheduled land, and I, whether the concerned circle officer issues notice upon the respondents, and Z, whether the petitioner is entitled to get the relief as claimed. However, the respondent sides did not appear during trial process to cross-examine the PWs, and hence the case proceeded ex parte thereafter. The petitioner side has examined as many as 4 witnesses, including that of the petitioner, and the cross-examination of the PWs had to be dispensed with default of the respondent side in appearance. Thereafter, during the course of trial, the appellant plaintiff had adduced their evidence before the learned trial court. Appellant plaintiff had adduced evidence on affidavit of 4 witnesses along with 8 numbers of documents as exhibits, and the witnesses were examined by the defendant. Heard argument from both the side of the petitioner. Argument from the side of the petitioner, none appeared on behalf of the respondent opposite side for final hearing. Here, I'll just pause for a moment. We had filed a written statement, but due to the negligence on the part of the conducting counsel, madam, no evidence was filed, neither any cross-examination took place, madam. We had absolutely no knowledge regarding that part, that our counsel was not taking any active part in the adjudication of the suit, madam, proceedings. So that's how, my lord, it proceeded. PWs were filed, no cross-examination on that point. Well, issue number 1, whether there is cause of action, that I'm skipping. Court has held that, my lord, there is cause of action.
This is not required.
Not required, my lord. And next one, B, that is important. Whether, issue number 2, at page 56, whether the grandfather of the petitioner, namely Bahan Hazong, along with Santa Hazong and Bokhonto Hazong is the father of our present petitioners, purchased a plot of land measuring 3 bigha 1 kothas under patta number 38, dag number 279 of village Pokharapara, Moza Boko in the district.
These respondents, they have purchased the land along with the.
Along with the petitioners, along with the respondents, they jointly purchased 3 bighas.
You all are brothers.
We are relatives, not brothers, but we are
relatives.
first cousins out of marriage. So by paying equal consideration, that is admitted from both the sides. Para 20. The testimonies of PW1 to PW4 establishes the fact that a plot of land measuring 3 bigha 1 kotha under dag number so and so was purchased by Santa Hazong, Bokhonto Hazong, and Bahan Hazong from Shashi Mohan Sil through one registered deed by investing equal share. They have also deposed that they had partitioned the said land equally amongst themselves, and thus each one got land measuring 1 bigha 5 desas as their respective share, leaving 5 desas of land for road. They have also stated that all the 3 aforesaid persons, namely Santa Hazong, Bokhonto Hazong, and Bahan Hazong, had possessed their respective share. There is nothing on record to disbelieve the testimonies of PW1 to PW4. The opposite side did not appear to cross-examine the witnesses, and eventually the case proceeded ex parte. Hence, the testimonies remain uncontested. Moreover, in the written statement of the opposite parties, they have stated in para 13 that in the year 1971, the deceased Santa Hazong, Bokhonto Hazong, and Bahan Hazong purchased a plot of land measuring 3 bigha 1 kotha under patta number 38, dag number 279, village Pokharapara, Moza Boko from Shashi Mohan Sil. Likewise, in the written statement in the para 11, they have also denied the execution of the registered sale deed number so and so. Hence, it is proved that Santa Hazong, Bokhonto Hazong, and Bahan Hazong had purchased 3 bigha 1 kotha of land in the year 1971. Now, this para is very important, madam. Para 22. Their names were mutated, saying, my lord, all the 3 purchasers' names were mutated over the said 3 bigha 1 kothas of land. Their names were mutated in the land records, and eventually their names were entered in the Jamabandi on the basis of Sitha. This is shown in Exhibit 2, Jamabandi. It is also clear from Exhibit 2 that their names have been recorded in the Jamabandi, which shows, this is important, that they have title and ownership over 3 bigha 1 kotha of land. That means, well, all the 3 have title and ownership over 3 bigha 1 kotha of
So
land.
that successor of Bokhonto Hazong.
My lord.
Then who else?
Successors of Bokhonto Hazong and Bahan Hazong. So they also have equal share, my lord. They
So
have also right title.
Successor of Bokhonto Hazong is the
Present petitioners.
You are the, and Hogan Hazong is.
And Hogan Hazong is the grandson of Bahan Hazong,
Okay.
my lord. Now, if I pause for a moment, my lord, and if my lord takes up the Assam Land Grabbing Act 2010, I'll just come to the definition part. Who is a land grabber, my lord? This is important.
Yes,
And-
yes, I got it, but this is not a criminal case.
My lord,
It has been separated.
separated.
So land grabber will be in the criminal case.
Well, why I'm saying, my lord, here, because the court has held that, my lord, I have illegally disposed them. I have illegally taken the possession of the land. But court has somehow held that I am not in possession, but I have to give back the possession to them.
Okay.
So that's why, my lord, I'm just reading the land grabber portion, my lord. And there is a judgment also to that effect from our Honorable High Court also,
Yes,
my lord.
yes.
Exactly on the
Division
same
bench
point.
judgment.
Exactly on the same point.
Division bench judgment.
Not division bench, single bench judgment of Honorable Justice Devasis Purohit.
Oh, that I.
Exactly on the same point.
Okay.
Section 2D I'm reading, well, land grabber. Who is a land grabber, man?
Okay.
Land grabber means a person or a group of persons who occupy or attempt to occupy with or without the use of force, threat, intimidation, and deceit land over which he or they have no ownership, title, or physical possession, and includes any person who gives financial aid. So, my lord, if I pause here, my lord, they should not have any ownership, no title. The court itself has held, my lord, that we have joint right titling interest and ownership, my lord. Once the court comes to the finding that, my lord, I am the joint owner and having ownership, my lord, then the very question of attracting the Assam Land Grabbing Act 2010 does not come.
What about the criminal case?
Criminal case is yet to start, my lord.
Okay.
While admitting the CRP, my lord, the matter was stayed.
Okay, we'll continue tomorrow. I'm not feeling well, suffering from backache.
Maybe part of partial, my lord.
We'll continue tomorrow.
Let it come on Thursday, madam. I have another matter to Thursday.
Okay,
If possible.
Thursday?
No problem.
Heard
Hearing
Learned Counsel, Mr.
A. Iqbal.
A. Iqbal for the petitioner and Learned Counsel, Mr. J. Huh? J. Ahmed for the respondent. List the matter on Thursday, Guruji.
18.